But 6 we file FDP, probably that is not coming the record. I may be allowed to call for.
Please call for it.
Lordship, with respect to item number 10, this matter, Lordship, I required 2 weeks time. So some development took place. The dispute between the petitioner, a society, and the private respondent. Lordship may take up in the first week of May. Lord.
Mr. Kal, this matters, we have only been adjourning. If there is something, bring it on record, we will
Yes,
hear
Lordship,
and close it.
that is required to.
On the prayer of Mr. S.C. Kal and counsel for the petitioner, list this matter again on 8/5/2024.
Lords.
May I please, your Lordship? Lordship, with the consent from the other side, I beg to mention item number 2 and 3. As my senior Mr. S.K. Mehdi is out of station.
On the prayer made on behalf of Mr. S.K. Mehdi, Lamet CGC, appearing for the respondents in the matter, list this case again on 23/4/2024.
On 23, counsel for the petitioner, Mr.
22.
Mazumdar will be out of.
22.
He will be out of station. Kindly matter may be taken up on 6th of or 7th of May. 6th of May.
On 6/5/2024.
May I please, Lordship? Lordship, I recommend item 62, my lord. Hearing matter, my lord. Under this matter, my lord, the pertains to the answer key, my lord. Can it be adjourned for a day, my lord?
Day means after big vacation.
After vacation on a hearing date.
On the prayer of Mr. D. Gogoi, Lanet counsel for the petitioner, list this matter again on 23/4/2024.
Oh, listen.
Item number 49 of today's list, my lord.
Hmm.
I have filed and reply affidavit. I am allowed to bring it on record.
Pasca Degree College. Okay. Give it.
My lord,
Yes,
I
madam.
mentioned for item number 7, your lordship, Mr. Sheikh is out of station, so the matter may come after big vacation, your lordship.
Mr. Sheikh is not here.
He is not available, he is out of station, your lordship.
On the
Any
prayer
date
made,
after big vacation, your lordship.
we'll release it from Pater. He'll be here on 18th.
My lord,
18th, he will be available.
18
Will he be available on 18th?
maybe.
1/8.
See, like, I cannot say, after, any date after big vacation, he instructed. me.
List this matter again on 22/4/2024.
Oblige, your lordship.
May it please your lordship, I beg to mention item number 12. Let it be taken after 1 week, lordship, for filing additional affidavit, lordship.
On the prayer made by Ms. N. Day, Lanet counsel for the petitioner, who seeks for an adjournment in the matter, enabling the petitioner to file an affidavit file an additional affidavit. Full stop. List this matter again after a week on a date to be fixed by the registry.
May I please, Lordship? My lord, the grade 1 judicial officer has been transferred from Udalguri to Jorhat. Now, her children are studying in Kendriya Vidyalaya on the basis of.
The High Court matters, you file it
No,
in
my
the
lord, it's
registry.
education matter, my lord. Education related matter. My students had not been allowed to join Kendriya Vidyalaya at Jorhat on the strength of a new notification issued by the Kendriya Vidyalaya Sangathan, my lord. This notification now excluded the rights of the state employees, my lord. Only they have now confined to the central employment. It's totally a case of, my lord, glaring discrimination, my lord. I pray, lord,
Get it. Tomorrow.
tomorrow. my lord.
May I please, your Lordship? May I please, your Lordship? Similar prayer, Lordship. The motion for tomorrow, if possible.
What is the urgency?
Lordship, matter pertains to regulation of service, Lordship.
Bihu,
Lordship.
Will please your lordship, item number 16. Lordship, I beg to mention to matter the passport for the D, lordship.
go ahead.
MSP DB, lordship. Learned counsel, she is out of station, lordship.
Selectively out of station. Selectively out of station. Nothing is there. Okay.
After Bihu, lordship.
List this matter, item number 16 on 18/4/2024.
Oblige, lordship. Mayor, with your lordship, I beg to mention item number 9 to adjourn the matter for the day.
Wait.
Actually, my senior is not well, so
Okay.
could not be present.
Mr. Noor Mohammed is not keeping well.
Yes.
On the prayer made on behalf of Mr. S.N. Mohammed, Sheikh, Mr. SKSN Mohammed, Lana Council appearing for the petition. This matter again after 2 weeks on a date to fix by the registry. Yes,
So that time also for listing of a writ petition, my lord, so that writ petition pertains to, my lord, non-issuance of appointment for want of benchmark disability, my lord.
for
My lord, want of benchmark disability, my lord, disability.
after vacations.
My lord, the only urgency is, my lord, the select list will, okay, my lord.
After vacation, what is the urgency?
May I please lordship, in item number 38, lordship,
30,
yesterday I have filed additional affidavit, lordship,
30,
38. Lordship, yesterday I have filed additional affidavit, lordship, can you call the additional affidavit?
call for it.
Thank you, Mr. Lordship. Item number 13, my senior is unwell, so kindly adjournment this matter after review. 13, my lord. 13.
You are bringing this, making this matter on behalf of
S. Upaida,
item number
13, my lord.
Huh?
13.
13. Oh. List this matter again on 24. 2024.
If they will.
On the prayer of the petitioner.
My lord,
Yes.
Our
Mr.
lordship's indulgence, my lord. I have filed a writ petition relating to, my lord, seniority dispute. I am holding the charge,
Tomorrow.
my lord.
You are here tomorrow.
My lord, yes.
Today's daily cause list, delivery of order item 1.
Anything?
My lord, my submission.
Short form regarding any SOP or rule, Malad. They have said that there is no such SOP or rule. That is not there, but before clearing the bill, the DBO must be Malad, regarding Malad genuineness, he must be satisfied. Malad, as there is Malad, the registration number was not there and the service tax number was not there. So Malad, they informed the their unit, Bangalore unit, and Bangalore unit made an inquiry before the cargo office. Subsequently, they have provided that Malad,
2 abilities. 2 certificates.
so Malad, it's not like that. Malad, from Guwahati unit, they have informed the Bangalore unit of CISF. They have enquired in their cargo office.
You have not inquired in the office here.
No, that
Yes, Mr. Chakraborty.
Well, my submission would be, just the snippet of my submission would be that if there were any suspicion on the part of the authorities regarding the
You
transportation-
used the wrong word, I suppose. If there was, there is only suspicion only.
My lord, because of the suspicion,
Ah.
what they did was they conducted a discreet inquiry. Your lordship has seen that.
We ignore everything.
No,
You
my-
show me. I have asked you, show me the particulars of your vehicle.
my lord, one thing after some kind of discussion, this will not help me, but still I'll place it before your lordship.
is again my household goods. Car is not there.
Absolutely, my lord. I cannot agree more with my learned friend. Car cannot be household goods. But my only argument in this regard would be that there was a bill of 98,700.
This bill does not disclose the particulars of
Yes.
the.
Car
Goods.
is not disclosed.
Go ahead, Vivek. Sleep well for the Bihu holidays. We'll pass the order on 18th.
My lord, that,
Okay?
that,
We'll pass the orders on 18th.
that squarely applies to the person sitting out there somewhere in Madhya Pradesh also.
I'm not worried. I'm worried about you.
My lord, I'll sleep well.
Have you spend your vacations?
Irrespective, my lord, I'll sleep well. My lord.
Spend your vacations well.
Obliged.
You will have the order on 18th.
Right.
List this matter again. I don't know. The parties to the proceeding have placed further arguments in the matter. So parties arguments concluded, list this matter again on 18th for delivery of orders.
Obliged.
Delivery of orders to calculated.
Obliged.
Top of the list, item 4.
Pass over for time being, lordship. After some time, lordship.
Hmm.
After some time, lordship.
Okay.
Obliged.
Item 5.
Please, your lordship, my senior is on legs in code 22. Kindly pass over the matter for the time. My senior legs in code 10, lordship. Kindly pass over the time.
Code?
Code 10.
Motion item 8.
Yeah, answer to Samir. It was in the. Huh? There is some requisition.
We have sent for into the registry. It has not come. It will come later.
Mr. Nath,
Yes,
they have filed some affidavit.
just now I got the copy.
You got the copy.
Just now.
You want to go through it?
I think so. I think it's better. better,
Mr.
better.
K.S.C. Kyle, Learned Council for the, ito, requisition to file to whom I give, Muk Didi.
19 days. 19.
Submits that an affidavit on behalf of the university authorities has been filed today,
No, yesterday.
yesterday. So a copy of this thing has been handed over to the Learned Council for the petitioner, senior council, Learned Council for the petitioner today. So Mr. M. Nath, Learned Senior Council appearing for the petitioner submits that he be given 2 days time.
2 days time, yes.
2 days, that means it will come up in 18th
After vacation.
vacation,
Let it can be fixed 19th.
19th.
19th, yes. Lordship will be probably here, 19th.
I should be.
Yeah, I let your lordships.
Let it be the week next. 23rd.
20 that I might.
No, when are you free? You just give me a date when are you free. This is Partha, no problem.
25th, no problem.
25th,
Yes,
on 25/4/2024 as a Partha night.
my lord. Let me see, my lord, what Brahmastra they have given. I want to see that.
I also want to look into it.
Well, I have submitted one short summary.
It's a very good day for you, you know. It's a really good day for you.
Sleeping well, my lord, for the view.
Motion item 8.
Lego. None appears for the petitioner on call. Heard Miss MS N. Pukon, Learned Standing Council appearing for the state respondents. Appearing for the Elementary Education Department. Appearing for all the respondents. So the petitioner, by way of instituting the present proceedings, has raised a grievance with regard to non-consideration of, with regard to rejection of his case for appointment on compassionate grounds by the district level committee, by the jurisdictional district level committee in its meeting held on 22/6/2016. So the petitioner has made a further prayer for consideration of his case for a direction upon the authorities for consideration of this case for appointment on compassionate grounds. Also, the father of the petitioner, late Mofizuddin, while serving as a chowkidar, bracketed grade 4 post in Kuari Pupuri Siddika, this at page 5, ये लगा हुआ है 2 word. Kuari Pupuri, 1 word, Siddikia, 1 word. Emi Madrasa died in harness on 1/4/2015. Full stop. It is submitted that the petitioner, being eligible for an appointment on compassionate grounds, submitted a representation dated 6/6/2015 before the block elementary education officer, Dolgaon block, praying for his appointment on compassionate grounds. It is the further contention of the petitioner in the petition that in the month of August 2021, he was verbally informed about rejection of his case by the constituted district level committee in its meeting held on 22/6/2016. Also, it is further the contention of the petitioner that the minutes of the meeting of the district level committee dated 22/6/2016 was received by him only in the month of September 2021. Also, in the above factual matrix, the petitioner has instituted the present proceedings, praying for an interference with the decision as arrived at by the district level committee in its Mongolway, in its meeting held on 22/6/2016, rejecting his case for appointment on compassionate grounds against a grade 4 vacancy on account of non-availability of a vacant post within the quota prescribed for appointment on compassionate grounds. Also, the petitioner, also, it is seen from the readings brought on record, from the materials brought on record in the petition, that the father of the petitioner had died in harness in 2015, and thereafter in 2000 on 6/6 died on harness on 1/4/2015, and thereafter on 6/6/2015 the petitioner had submitted his application. There is nothing brought on record to demonstrate as to how the petitioner and or his family members were pursuing the matter pertaining to the appointment of the petitioner on compassionate grounds. Also, even after coming to learn about the rejection of the case of the petitioner by the district level committee in the year 2016, sometime in September 2021, the present line number. Also, the petitioners have not demonstrated as to how the family had sustained itself. It is seen that after the death of the government employee, the family of the petitioner had sustained themselves, and after lapse of around 9 years, there arises no occasion for this court to direct the respondent authorities to appoint the petition on compassionate, to consider the case of the petition on compassion for appointment on compassionate grounds. In this connection, the case of the decision of the Honorable Supreme Court in the case of Debobroto Tiwari, वो बाकी है, तो उसे लेके वो लगा देना पड़े. Dispose of. Dismiss, sir.
Item 11.
Yeah, should respondent number 2 file their affidavit, my lord, I may be allowed to file
what will you file here? What more is left here? Tell me, what are you going to state? They have said the fact, which I am telling you from the day one, that you have given the land, forget it. You've given it to the school get amalgamated with some other school. The government has a policy how their land would be utilized. That land goes with the school. The government will utilize it for a purpose. How can you get it back?
Worship land is being vacant, my lord. We want to.
Vacant, you have already given up, mister, and the deed does not even make a mention to this effect, that it is a conditional transfer.
Yes.
The deed is a full alienation of the property. What more is there required? You have given it for a societal purpose. Let the government decide what it will do with the land. It's not with any private individual. It is with the government only. The government will bring up some developmental activity there. And that is exactly what the director has said in the affidavit.
We want to establish educational institution.
Huh?
We want to establish private institution.
You buy a land and establish. Who is preventing you? Buy a land and establish. We are not preventing you. But we feel that this is not a fit case for issuance of any mandates.
Worship, we may be allowed to file civil suit laws. Because
Don't rush into conclusions. Think over the matter. We'll pass orders on 19th.
most of it,
List this matter again on 19th for
most of it.
2024. If you want to file, you file and reply. But this was the view of this court. You go file civil suit, you go file applications, we have no objection, but we cannot direct. Once you have alienated that property, gifted that property, now you can't say, come back one fine morning and say that, no, I want my property back. Not permissible. Yes. 19th.
Yes, most of them.
Yes.
Item 14.
Yes.
Compassionate appointment letter. Petitioner filed the application or to give
Yes.
the authority. But
Now,
not placed.
show me the receipt of page 25.
Yes,
Otherwise,
okay.
I'm going to impose cost. I'm going to impose cost. You show me that receipt of page 25.
Lordship, as per instruction from my client,
Hmm.
he filed RTA application.
This order was passed in 11/12/2023.
Yes, Lordship.
Today, RTI application time is also over. So it is a bogus application. This whole thing, this page 25 was made only to come before this court.
Yes, Lordship.
So, should I proceed with the matter?
Lordship, I may be allowed time.
We will not allow you time.
I will produce the
No,
RTA
you can't.
application.
You would have produced it if you had it today. You don't have it. And now we will hold up your client, hold up your petitioner for filing this frivolous petition. This is frivolous. Only for the purpose of approaching this court, you have made this. Why?
I may be allowed to do.
Will not even permit you to withdraw. I'll give you time till 2 o'clock. Get that document, otherwise 50,000 rupees to the Bar Association for wasting the time of this court. Why? Why do you encourage such sort of things? So Nazir you are an experienced hand now in this court. Done many cases. Why do you permit such? And say there is a specific order of this court.
Yes, Lordship.
Why? And that's not my order. So another court had also the same view. And tell me, how was your family surviving all these days? And if it has survived after the death of the person in 2002, What is the beauty in issuing and direction today?
At the time of death, Lordship, I was minor.
Minor.
Yes, Lordship.
So you became major after 10 years. And the compassionate thing is something which is hereditary. Is it a hereditary thing post?
Page 20, Lordship. Legal here.
I've seen it. 10 years. 9 years. 9 years.
Yes.
Mr. Nazir, you'll dismiss it. You'll not proceed any further. Will not trouble you during it. You'll have the order on 18th. Disposed of. Dismissed.
Obliged, Lordship.
And next time, if I get an application like this, motion stage itself, I'll impose cost.
Lordship.
Item 15.
None appears for the petition on call. Yes. You're proposing to consider him like the other cases? No. Dismiss. Dismiss. Sir.
Item 17.
NIT workers,
Just a moment, just a moment. Mr. Kaushik, you will be appearing in the other matter? Elementary. You can appear. We have dismissed it. 98,
Lordship, otherwise,
date of death.
I would just to one highlight, Your Lordship, at page 11, Your Lordship, in
Hmm.
that next of kin, Your Lordship. No, no, take it, Lordship.
Yes.
We'll find that in that next of kin, what we find is that, the one who is in the 5 or 5 or 6 number, he approaches me. So if he wasn't die in harness, the other,
May have,
Sport,
may,
yes.
we don't know. We
Yes.
don't know.
17.
Issue, heard Mr. MJ Borwal and counsel for the petition. Issue notice. Returnable 4 weeks. Petitioner to take steps for service of notice upon the respondents, steps within 3 working days.
obliged.
18.
Lives this matter before any other bench without me. Without me, I can't take up
Obliged.
any other bench.
19.
I'm getting mental harassment, my lord. See,
Mr. Counsel. Now we will drop contempt proceeding against your client.
My lord.
You come to page 16. Is this the order, interpretation of our order? Read that nicely.
no, my lord.
Then that shows that she was never in charge on that day. Somebody else was in charge.
No,
Otherwise, no. And continued in charge. What is this? Where is this interpretation she has got? That is not the order which we passed.
Yes, yes.
Then the matter is fixed on when?
24.
24.
24.
You withdraw this. Otherwise, if we have to proceed, it will be bad. Have it on 24. That entire matter, we will hear it. But this, with this statement, I can't. I'll not issue a contempt, and we don't find any willful and deliberate violation here.
And my lord, page number 18, he sent me a legal notice.
Huh?
He sent me a legal notice. In fact,
What?
I am a private respondent number 7 here.
Huh?
Page number 18, my lord.
Huh?
He sent me a legal notice, my lord, to my client. My lord.
Legal notice.
Legal notice, yes.
That is okay. What
But
is?
I am put a private respondent, my lord.
No problem.
Actually, my lord, she is harassing me, my lord. She is main respondent is she is doing some illegal activities. And with the help of local people, my lord, and with the help of managing.
When
committee,
did
my
you
lord, she
take
is
over
in
charge,
representation.
Mr. Bro?
15-3, my lord.
Huh?
15-3,
And the order of this court is?
19.
19.
What is the document to show that you have taken
My lord,
over?
today I have no, my lord, because I don't know this contempt petition, my lord. Just before he sent me this copy, my lord. If
Why,
my
why
lord,
did you send him that copy?
if my lord
What do
can
you want to
help me,
do?
my lord.
Continue. Then I'll ask for an explanation on this. Page 16. This is not the way you interpret orders of this court. We only set status quo. Whoever is there, is there. We did not say that the petitioner will be allowed to
I
continue.
am sold, my lord, for this interpretation, and I will do, matlab, whatever as per the order of the, that is 19th.
We have
But-
made it returnable on, I think, 24th.
24 years.
On 24th, you try your, bring on record materials, file an IA,
Yes.
explain.
Yes.
With this, we will not proceed. And he says that he has already taken over charge on 15th.
No, no.
You were in charge. What
Yes,
is that formal handing and overtake requirement? It's not there.
She has not hand over.
And you have even mentioned that she is signing the bills of the teachers.
Yes.
Then,
But so DDO's dangle also she is manipulating, and salary is pending.
you file an FIR to that effect. Go and file an FIR on yourself. If she is manipulating things, materials are there. Go and file. Withdraw. You are Mr. NJ Medi.
Yes.
Mr. NJ Medi, after Mr. NJ Medi submits that he be permitted to withdraw the present application and prefer an appropriate application in the pending writ proceedings. So, prayer accepted, contempt petition stands closed.
Obliged.
20 to 23.
May I please, Lordship, kindly pass over the matter for time being.
Wait,
Mr. RD is legs on other court.
But I've received the instruction, my lord.
no, receive.
Received this.
Hmm.
Possibly the question which you have also raised, that as to whether, what is the manner the school managing committees are formed.
Hmm.
And whether some departmental authorities act as an observer.
Hmm.
Well, I have given the instruction.
No, this is, we all know. This is there. But why is it not being implemented?
My lord.
Why is it not being implemented? That was my idea. We
No,
know
it's,
that this is just a copy paste of the rules.
it's not like that, that it's not implemented.
No, it's only CRCCs who are there.
No, it is one case, my lord, has.
No.
that is here.
Many. I'm
Otherwise,
sitting
you
here, I'm getting Mr. From today onwards, I'll make a count. I'll keep a count. Every case, either there is no one or there is a CRCC. Why?
Otherwise, my lord, this, as per the rule, my lord, it's specific, my lord,
It's specific.
specific.
Okay. Mr. B. Kaushik, we will, who was there? Who was making a mention?
Item 23 perhaps. 23.
We'll have it after some time. Let Mr. Day come.
My lord. Or I'll file a affidavit to this effect, my lord.
Let him, because he made a mention.
Mal.
Before him, I'll pass that order.
24.
Just wait, let Mr. Day come.
May I please, your lordship? Matter for withdrawal, lordship, petitioner got relief, lordship.
Get it close, close. 19 close. Close there, 19. Close there.
Matter for withdrawal, lordship, petitioner got already relief. They got admission, lordship.
What more is required?
Medical.
Your name, madam?
J. Ghosh.
J. Ghosh, Learned Counsel for the petitioner submits on instructions that the petitioner has already been permitted to undergo the compulsory internship, na?
In
a compulsory internship. Compulsory
compulsory
internship program. Also,
rotating
accordingly, she prays that the matter be permitted to be to be closed as in prays that the matter be closed as infructuous. Prayer accepted, repetition stands dismissed as being infructuous.
oblige lordship.
25.
We must thank Mr. Buddo for that.
May I please, your lordship? Lordship, Mr. DP Bora is on lake, lordship, so this matter may be taken up after some time.
Okay, okay. No, we'll not pass any adverse order. Just hold it.
Please.
After some time.
26.
On last occasion, some discussion was sought for lordship. Regarding.
Yes, yes. What is the direction?
I have received the order
Yes,
of
give it.
the hearing. Madam, they are not taking the permission from the appointing authority regarding the their DH or DH degree. So therefore, my lord, the school inspector is directed to draw the proceedings.
Yes.
Earlier, the
Give him a copy.
Yes.
Give him a copy.
Yes, sir.
Mr. U. Sharma, Learned Council, Standing Council, Senior Secondary Education Department has placed before this court a copy of a speaking order of an order dated 27/3/2024 passed by the Director of Secondary Education Assam, disposing of the representations as preferred by the petitioner in pursuance to the directions passed by this court. For disposing of the representations preferred by the petition. So, copy of the said order dated 27/3/2024 is kept on record and marked as X. Mr. U. Sharma shall furnish a copy of the same to the petitioner for his perusal. Petitioner is permitted to make his submissions thereon on the next date fixed. List this matter again on 26/4/2024. You take a copy from Mr. Sharma.
Yes, yes.
27.
Please, your lordship, lordship kindly pass over the matter for the time.
Yes, Mr. Mazumdar. Gender neutral or
Yes,
gender neutral?
gender.
Then-
I will read the regulation, my lord. I will just read one part of the regulation.
15,
Says
15 regulation.
3D.
Hmm.
And read. Act decisively against all gender-based violence perpetrated against employees and students of all sexes, recognizing that primarily women employees and students and some male students and students of the third gender are vulnerable.
Show me. I missed out on that. So this is something which goes further than the harassment act.
Yes, yes, because now the students have been recognized in that. So she will have 3D. responsibility of higher
Just
education, 3D.
Women employees and students in higher education institutions, agreed women employed. Will not pass any, Mr. You take your breath.
She could also have 2L.
Two?
2L, it does not speak of the sex of the student role. Student means a person duly
No, I've
educated
seen it.
person.
I've seen
Person,
it.
it's
There is
always
no
a-
distinction.
Term is always used as person, and 3D makes it to a large extent clear.
Yes, Mr. Monto.
My lord, 3D, your lordship kindly see that section, regulation 3D.
Ah.
It does not make, my lord, is gender neutral. Why, your lordship kindly see, your lordship kindly see the heading, my lord.
No. If you read it further, act decisively against all gender-based violence
No,
perpetrated
your
against
lordship- Before
employees.
that, your
and
lordship kindly read the section 3. Regulation 3, my lord.
students.
heading.
Responsibilities of.
Responsibilities, my lord. These are the things, my lord, they have to do, my lord. So your lordship kindly see, to make awareness, make things, my lord. These are all these, my lord, responsibility cast on them. But it is not overruled, my lord. Your lordship kindly see the person agree. Person agree, your lordship kindly see.
Agreed woman.
My lord, yes, agree movement.
But you have
No,
a
your
definition.
lordship kindly,
You have a definition in 2L of student.
my lord. No, that,
Student again is gender neutral.
then your lordship kindly see very name and culture, my lord.
Huh?
Very name and culture, your lordship kindly see. Name and culture of the, my lord. The redressal of sexual harassment of women, employees
Employees.
and students.
Student.
And student, employee and student, not all student. And student means, my lord, is a female student, my lord. Men, oh, your lord, let me finish. Your lordship kindly see why I am coming, my lord. There is lots of debate. Even the Supreme Court, there is a judgment of Justice Bhuya, my lord. I'll give you, my lord. What happened, my lord? The main purpose, my lord, what? Protection of women in workplace. That is the main concept of the Visakha's case, my lord.
Hmm.
From that case, my lord, this regulation is from. The main regulation is what, my lord?
Where is the objective of this regulation?
Yeah, this is my lord, main act, my lord. Your lordship kindly see the act.
No, act you've covered under so.
Oh,
This has got no reference to the act.
Yes, there is a reference, my lord. I'll come to that, my lord.
Where? Just show me.
Definition, my lord.
No, your definition.
Yes, my lord.
Where?
The act means to be.
Okay,
Act means sexual harassment of women workplace.
okay.
That's it.
Okay.
Now your lordship kindly, everything will be
Enough,
clear.
enough.
Everything will be clear. Justice Bhuya judgment, very
Enough.
clear.
I got it.
That even in the Supreme Court, my lord. Even in the Supreme Court, my lord.
He always takes me in a circuitous. He never.
No,
takes me
that's why, my lord, what I am going to submit. Yes, let there be a lead case, my lord. Let him file a affidavit. Will, my lord, your lordship kindly examine at that point, my lord. It's a point to be decided, my lord. Now, my lord, Justice Bhuya also, my lord, clearly mentioned that, my lord, in Supreme Court, whatever I am submitting, my lord, Supreme Court, my lord, Supreme Court employee, my lord, they try to include in that, my lord, the female, male and LGBT also included. Then no, we cannot directly do this, my lord.
That was
The
the case of
main
an act.
purpose will be
This is the
frustrated.
case of a regulation, my lord.
Mr. Majumdar's argument cannot be brushed away. He has a point.
My lord.
He has a point because what he is trying to define, trying to bring on record is by taking the definition of student and then reading it with 3D.
Yes.
There is an arguable point.
So that's why, my lord,
There is an arguable point.
Yeah, my lord.
Because first day I was also not very inclined with him. That's why I passed an interim direction. I'm not going to change it. let it be maintained, but Mr.
Let him file affidavit. What I'll file my affidavit.
No affidavit is required. Make your submissions. This is the point of law, interpretation of that regulation only. What affidavit is required?
But here is the situation, if what the Supreme Court in 2023 CJS judgment is there. Technicalities or other things should not interfere in the proceedings when it is an act of sexual harassment or the complaint is of sexual harassment.
We got it. But here, why we are on this job,
And this is.
why we are, Mr. Majumdar, why we are on it.
Madam.
Will, if required, we'll give our reasons. If you don't want to make your submissions on that point, fine. We'll make our reasons clear. Because the act, if we read it casually, yes, what you said cannot be brushed aside. But if we go detail into the act, it's basically following up on Vishaka.
Madam, that was an act.
But I got it. It goes following up basically on Vishaka. And 3D is the requirements as to what they do. And therein also, you will
We
find.
have to act decisively when there is a.
No. Come to that
And
three.
the term used in the act, when the act itself says, my lord, that it is a woman.
No, the act is here, the
Then
act that is referred to here in 2B is the act of 2013.
But the 2B is only the act, but the definition of a student does not refer to the act. Lordship will find that act in the sexual harassment of women at workplace does not refer to.
We will hear it.
students.
When? When are you coming back?
I'll be back on the second.
Second. We'll have it on 5th.
What happens in this, I'll put it the straight away. Here is an attempt of the university just to find out. Because even it is even the submission of the petitioner and it is not denied by the university. If it is a false allegation, students also stand.
Now,
Now,
Mr.
there is also a provision of, my lord, bringing about a, what do you say, understanding or having it reconciled. That is also there, but here is a case, my lord.
It cannot be reconciled. If it is there,
It is there in that. It is
It
there in
is-
the regulation. Lordship will find. Lordship will
similar
find.
provision like the other one, conciliation.
Yes.
In the act, it is conciliation.
Yes, it says. Consequence, there
If
was,
you come to 4, section 4,
oh, yes.
Huh?
Reverse redressal mechanism.
you come to
Every
A,
executive authority shall constitute an internal complaints committee with an inbuilt mechanism for gender sensitive.
fixed body, and the chairman is a lady.
Yes, has to be, because the maximum complaints, Lordship will see 3D once again. It is primarily the woman. But
No,
now.
if it is a male,
Madam,
if it is a male,
if it is, no, what I'm saying is this. Primarily, it is all, the section 3D itself recognizes that primarily it will always be a woman who faces it. But what do we recognize? Act decisively against all gender-based violence perpetrated against employees and students of all sexes, recognizing that primarily women employees and students and some male students. What is this "and" word? Supreme Court has held it is disjunctive. It creates its own class when a word comes after the "and." That has also been accepted by this honorable court also in several cases when I had the judgment. This "and" itself will change everything. It will be male students will also be covered and third gender students. Students, my lord, in an university, when a student is under a supervisor pursuing a particular PhD. But I even went to the extent of having discussions with doctors, psychiatrists. They say they have students coming in because of this kind of behavior of
Harassment.
some persons. It is not all. Some
Okay,
persons.
when?
Now, the statements also.
Okay,
Lordship,
fine.
once I can
When?
have.
when, you
Like
get
that.
me your judgments. Interesting, when?
I'm back on the 5th, my lord. I'm back on the 1st.
Hmm.
Any day after, 2nd, 3rd,
We'll finish it up on that day,
6th.
6th.
My 6th.
Not keeping it parted, if it comes to me, we'll hear it, but otherwise,
At this stage, my lord, another thing that I'll just point out, my lord. The last stage at which the proceedings were before he came here was at the cross-examination of the complainant.
wait till 5th next day
Fine.
and thereafter you proceed.
And there.
Let us get a clarity on this issue. Because I can't, on the face of it, brush aside Mr. Monto's argument also. If you go to the complaint grievance dismissal, then the complaint, who uses the word aggrieved person. It uses the word aggrieved person. If you come to the,
Agree person not defined.
no, clause 7,
Yes.
regulation 7.
7 years.
An aggrieved person. Person. But here, in your definition, you have used the word aggrieved woman.
No, aggrieved woman I have not used. Aggrieved woman.
Yes, yes, you have used the word aggrieved woman, 2A.
2A. The 2A is a definition of an aggrieved woman, but there is a student also.
I got it. But
At
here, hey, get me the 2013 Act. I have a
At
copy.
L when I say
2013 Act copy.
2013. Yes. Yes. 2013.
Here also, aggrieved woman.
Women.
13. 13 is an act which starts with the word sexual harassment against protection of women at workplace. Here is a educational institution you're talking about, therefore UGC has to step in. It is not a workplace. It is an educational institution where the control over a student is far more than a superior officer over a inferior lady officer. If I may say, if I may use the word inferior, it's not inferior, that's in rank. A student is in a far more vulnerable position.
You come to M. 3M.
Third party harassment.
No, 3M.
Treat sexual harassment as a misconduct under service rules and initial action for misconduct if the perpetrator is an employee. Now, here also there is a Supreme Court judgment which says that if the ICC cannot take a call due to whatever technicalities, immediately the report of the ICC will flow as a
Inquiry report.
it will be treated as an inquiry report, and then if necessary further.
These people in
Options
your
will be
university are this is the
We are still on
Dibrugarh.
the fact finding part. Whether
You are
something happened.
Dibrugarh University.
Yes.
So you follow the Assam discipline and appeal rules.
We have our regulations for teachers and
No.
non-teaching
The
staff also.
disciplinary proceedings.
In principle, we follow some discipline, but we have our own conduct regulations.
The amendment as made in the CCS rules in this connection with regard to the Act of 13 is not there in the rules of the state.
On the state it is not there, but we have got our own conduct rules where this.
And therein have you put it that the report of the inquiry officer would be the inquiry report?
The CCS rule says inquiry of the committee will be the inquiry report. But here so far as the Supreme Court judgment says where these provisions are not there, the inquiry, if the ICC cannot come to a concrete conclusion, this will be set the disciplinary report, which will be now taken up as a preliminary report, a fact-finding report. And he will be given due opportunity and then all the rest will follow.
Okay.
But here we want to find out the fact whether we need to proceed or not.
Heard,
It is where it is hanging.
heard Mr. T.J. Montal, Learned Counsel for the petitioner. Also heard Mr. R. Mojumdar, Learned Standing Counsel, Dibrugarh University. So, Mr. R. Mojumdar, by referring to the provisions of the University Grants Commission bracketed prevention, prohibition and redressal of sexual harassment of women employees and students in higher educational institution bracket over regulation 2015 submits that the said regulation, unlike the provisions of the Act of 2013, is not limited to the females or women employees, but is also applicable in case of students. And insofar as the definition of student is given in the regulation of 2015, the same is gender neutral, right? Accordingly, in the present case, the issue being the perpetuation of such an act upon a student pursuing a course in the university by the petitioner herein from the ICC as constituted under the regulations of 2015 would have an application, and an inquiry therein cannot be said to have been held without jurisdiction. The above issue requires a detailed hearing. Accordingly, list this matter again on when? When, Mr.
My lord, I am always available, my lord. I am from Minopol. But I want little accommodation.
24 into 7 advocate.
But I want little
I learned
accommodation.
from him.
You and I sleep, he also sleeps, but somewhere the counter is always ringing. That is the beauty of Mr. Monto. Yes, when? You're a busy council, so I'm asking you. Monto is available always.
2 weeks in a year, my lord, I need that. I'm back on the first, my lord. In the
Let it have it on the 7th,
My lord.
7/5/2024. Interim order passed earlier to continue till the next date of listing.
Develop. Develop.
Do you have an extra copy of this?
This regulation.
I'll give it.
It is available in the
I have
house.
everything.
Then what I'm doing is,
I'll
these
give
two
it for
copies, I'm keeping it for my
my
person.
lord. And
But this is something which I have to read now.
My lord, 7th of May, my lord, will be exercised.
So.
oh yes, declared holiday.
9th of May, 9th
It's
of,
a declared holiday.
9th of May, 9th of May, sorry.
My lord.
Obliged.
So concerned about his constitutional rights.
Yes, right.
voting
Right.
rights.
28.
Yes. Hmm.
The matter is pertaining to appointment.
When was the list published? Select list published.
Lordship,
Select list published.
yes,
When?
actually, it is published on 2nd of
No.
'22, 23, Lordship.
Huh?
Nine, 12, 22, Lordship.
9/12/22.
No, it is 26, 12, it is published on 30, 12, 22.
30/12/22.
30, 22, it is prepared and published on 21, 2023, Lordship.
Heard Mr. D.K. Dekh, Learned Counsel for the petition, issued notice returnable 4 weeks. Mr. S. Das, Learned Standing Counsel, Higher Education Department, accepts notice on behalf of
1 and 2.
1 and 2. What is this party? The petitioner to take steps for service of notice upon the respondent number 3 by way of registered post with AD. Also, on the returnable date, no formal notice is to be issued. On the returnable date, Mr. S. Das shall apprise this court as to why the petitioner was not extended with an appointment against the unreserved post for which he was shown to have been selected in the select list published in pursuance to the advertisement dated advertisement is dated
Advertisement dated is 27/8/2022, Lordship.
27/8/2022. Let him get his instructions. The issue of maintainability of the writ petition is kept open. 1 year had lapsed.
But in the meantime, already.
That just we have kept it open.
29.
Mr. The order is not yet finalized. Is typing it out. So we'll pass the directions, whatever is there, we will pass it here.
Only where B Pharma and registration issues there.
You have cleared the examination when?
Is on August 2023. Some of the petitioners, dates are different.
But we'll not make it specific. We have only said that if you are covered by the PCI regulation and the circular, then you will not be given a provisional registration. If not,
Then-
before that, you will get it.
Along with the other petitions.
The directions we'll copy paste it here.
Obliged.
In Mukhali file. এইটো ফাইলটো খালি এইটো ডিসপোজ নহয় দেই
petition
অৰ্ডাৰ দিয়া আছে বেলেগ চিমিলাৰ মেথডত মই অৰ্ডাৰ দিয়ে পাছ কৰিছো কথা এইটো টাইপ কৰি আছে চ' চিমিলাৰ অৰ্ডাৰটো ইয়াতে ডিসপোজ অনলি ইনফিল্ড ডাইৰেকশ্যন
my lord has this
বন্ধ 9 এইটো 15/5 15/5
my lord has disposed of it.
no
Notice is
15/5 15
Item 30.
30 31
Lordship,
parties are same in 30 31
my lord,
respondents are same
respondents are same, my lord.
দুটা একে also বেলেগ বেলেগকে মাৰিব heard Mr. A. Hassan, learned counsel for the petitioner. Also heard Ms. M.S. S. Chutia, learned standing counsel, elementary education department. Anyone more? Mr. Bro, you are appearing for?
31.
Huh?
In item number 31,
Huh.
on behalf of accountant general register of 4.
Respond number 4.
In item number 31.
Only.
Yes.
And 32 who is appearing?
30.
30th.
Or 30 you are appearing for? Name?
Accountant general. Accountant.
Okay. Miss A. Sharma, learned counsel appearing for the accountant general, and Mr. B. Dury, learned government advocate. Issue notice returnable 4 weeks. Ms. M.S. Sutia, learned standing counsel, elementary education department, accepts notice on behalf of respond number 1, 3, 6, 7, 9, 10, 9 and 10. MS, Mr. Upward order legal, Mr. B. Google, learned standing counsel, finance. Mr. B. Google, learned standing counsel, finance, accepts notice on behalf of respondent number 2, 4, 8, and 11. Ms. A. Sharma, learned counsel, standing counsel, accountant general, accepts notice on behalf of respondent number 2. Mr. B. Dury, learned junior government advocate, accepts notice on behalf of respondent number 5. All done? Huh? As all the parties, the respondents have been represented, no formal notice is to be sent. However, the petitioner to furnish requisite extra copies of the petition to the learned counsels appearing for the respondents within a period of 3 working days from today. What was it? 31?
Lordship may fix a date, my lord. And date may be fixed.
4 weeks. You complete your letter and file. 31 not. You are for 31.
Yes, ma'am. That's one of 4 days for accountant.
AG নাম তাতে খালি আপনার Mr. C. Burua, A. Sharma জায়গায় C. Burua করে দিন। The rest parties are same.
Same.
Right.
If not same, don't come back with an application for correction.
My lord, here only finance is my lord 8 and my lord 8 and 10, my lord. There is no 11, my lord.
That's why I told you.
8 and 10 for standing under finance.
Ms. S. Sutia, learned standing counsel, for respondents number 1, 2,
2 finance department.
6, 7, 9, Bishop Finance Department 2, SC Finance it was
2, 8 and 10.
8 and 10. Bishop AG Hole 4, C. Burua. Mr. B. Dury Hole 5.
Obliged.
32.
The similar case has been fixed on 24th of April, my lord.
Very good. Let's this matter again on 24/4/2024 along like
That
24.
is 1/4 of 2000.
24.
Yes,
Other
I mean,
matter is on
24th
24th.
of April, my lord.
April.
Corrected, my lord.
24. Okay.
33.
similar method lordship has fixed on 26/4.
For what?
for instructions.
Why?
Lordship, what has happened, we are.
Now tell me, Mr. Bora, where is that qualification looked into in the requirement of that? If there is a person fully qualified
Yes,
and there is another person who is not qualified,
yes,
he does not have a PhD and all,
yes.
he should not be preferred, but the person who is having the qualification should be preferred. In the context of our act here,
No, Lordship,
where is it?
that is my point. My point is that.
Have you challenged that provisions of the act to that extent?
No, Lordship,
Then-
nobody can be left out as per this act.
No. There is a limit. If one post, I think 80 candidates. No, one post 30. One post, first post 30,
Yes, my lord.
second post 80,
80, then.
third post
150.
150. So you don't have the strength for two posts. It's 30 and 72. Economics 30 and Pol Science 72.
Yeah, but the basis of the provincialization is taken as seniority.
Seniority. Now you are not senior. There are two persons other than senior than you.
But in the act, Lordship, whether that is the basis or not.
Act, if there is something, you have to make a challenge to that act.
No, Lordship, seniority is not the criteria. Earlier, that is why the earlier act was struck down because of the schedule.
So there has to be a selection. That means then,
Yes, that can be done.
then whatever has happened, what will happen? I don't think so. That's the context.
Lordship, otherwise,
The first post holder, they go by the first post holder, second post holder, third post holder
yes,
in a college.
yes.
So first post is the person who is the senior most.
They have
Second post,
taken it.
the next one. You are basically second post holders.
Yes,
And for that, you will have to have something more than 80.
80.
You don't have.
But in the earlier act, seniority was the criteria. But
Mr. Das, you receive your instructions.
in this,
Mr. S. Das, Learned Standing Council, heard Mr. B.P. Bora, Learned Council for the petitioner. Mr. S. Das, Learned Standing Council, appearing for the,
I'll be appearing, my lord,
no.
1D.
One of Mr. Standing Council, Higher Education Department, submits that he be granted 2 weeks' time to receive his instructions in the matter. Accordingly, list this matter again on 25/4,
this
2024.
other matter is 26/4.
26/4,
My lord, I think
2024.
BTC will be proper party, my lord.
Huh?
BTC, my lord.
Oh, it's
Because-
BTC.
BTC is there. BTC 9.
S. Das or Jagat, Mr. B. Chaudhary.
It is
It's a
there.
BTC area college.
Yes, my lord.
Yes, Musalpur.
Okay.
Musalpur college.
Mr. Chaudhary,
Yesterday also,
examine.
same college, another professor came across this.
Yes, yes.
Yesterday also.
yesterday also.
Yes.
Was a matter, there was a matter here.
Yes.
Yes, that is the matter, that is. which one
26, I think.
26/4.
Okay, you have your instructions. Mr. B. Chaudhary.
34.
So now we'll issue a notice here now.
Lordship, or Lordship may also direct, dispose of directing the authority to recommend his, examine his case by the district scrutiny committee.
You have,
They will examine whether he is
Yes, sir.
eligible or not.
My lord, already district scrutiny committee has rejected and did not recommended his name, my lord.
Earlier recommended, but Lordship rejected on the ground that DSC constituted in the new, under the new act, he has not been recommended.
And moreover, my lord, he has no enrollment. Yes,
Let the DSC decide that, Lordship.
low enrollment, where do you get it?
my lord, page 73.
Hmm.
2017 is 8. Number of students.
You are the only teacher, Sanskrit teacher.
Only teacher. Also from 17, 18, 19, or 8, 9, 10, 13, 10 students.
Number of
also.
students, it would change.
List this matter again on 22/4/2024. Don't have a case.
Lord, then notice may be issued. Also.
We'll pass the order. on 22nd, not after 10 years. How's that one? We'll give you a liberty. If you want, you can go before the authorities. But no mandamus, no direction. You don't have the minimum criteria. And you have annexed that. The night, it just missed my. Pause your, enjoy your views. After that, we'll pause.
Supplementary course list, motion item 63. 63.
That we will.
What do you want?
My lord, the similar matter is pending, my lord. Order, my lord, page 75, my lord.
Mr. Bora, what is, this is not a provincialized school or provincialization. Regularization as a tutor, but from where is this concept developed? Tutor concept. Tutor concept.
My lord,
In normal schools, from where it has developed?
tutor,
There's something, policy decision.
my lord, tutor are not qualified, my lord. Yes.
No. You have, you're not a provincialized, you're not seeking provincialization.
My lord,
You are
actually, my
stipendiary
lord,
teachers.
Actually, my lord,
You are stipendiary teachers.
like that,
initial-
my lord, they are irregularly appointed, my lord.
And they are regularized as tutor.
My
Tutor is there in the 2017 Act.
My lord.
How can it be applicable in the, how do you apply it in the other persons beyond 2017 Act?
2000,
Tutor concept is in the 2017 Act.
my lord,
He is not a person who is subject of 2017.
my lord.
How come he is regularized as tutor?
My lord, probably illegal, irregular category, my lord.
To show me that irregular will be tutors.
I will,
They are entitled to regular appointment if you find them that they are eligible. They should get full salary.
they are appointed, this illegal, irregular were appointed as.
I
per-
got it. How tutor? What is the basis? On the next day, apprise me on that.
My lord, they have not.
Mr. Big Bora Learned Counsel for the petition respondents. Respondent Elementary Education Department shall apprise this court as to the policy behind appointing persons found illegal to have been appointed on appointed in an irregular manner as tutors, as was done in the case of the petitioner's hearing. Also, the above instruction be placed before this court on the next date of listing. List this matter again on 26/4/2024. Just get me that, just for my curiosity,
My lord,
from where you have drawn that concept. Because they are not subjects of 2017 Act.
my lord. Oh, bless. It is, my lord,
Six-
on humanitarian ground, my lord, given, my lord.
Huh?
It is on humanitarian ground given, my lord.
Humanitarian ground also should be by law.
Some, my lord, policy decision must be there.
We'll see.
64.
Oblige.
Wait, but this third round of litigation, my lord, earlier, my lord, this petitioner, petitionable court. Petitionable court, my lord, directed the authority.
What do you want today other than a motion? Notice of motion.
The commission order may be state.
I would have stated, but
23, my lord.
the SEBA has said, you are not the appropriate school. SEBA's order, inquiry order, you are not the school. The school, actual school is somebody else, and that writ petition is pending before this school. And this court had not passed the interim direction.
This is not different, this is a different case, my lord.
Huh?
This is a different case.
Nayan Jyoti.
Hanjo,
Okay. This is different. This is different. Oh, yes, sorry. This is different. Year 2001 onwards, you are not there.
no, my lord. I was transferred to one.
You
school,
did
my
not
lord.
join there.
That transfer order was stayed by the authority itself. And I.
Where is that stay order?
Yes, my lord.
Because
Transfer- stay
in the
order was
earlier
different.
proceedings before this court,
Page 31.
in the earlier proceedings before this court, the stay order is never reflected.
Yes, my lord. Page 31.
No, tell me why. In the earlier proceedings, this stay order is not reflected.
That
Why?
I admit, my lord. I did not know, my lord.
We'll not go into that today.
Page
We'll not
31
go into that.
Page 31 is the, my lord, stay order.
We'll not go into that.
And the headmaster of the original school, my lord, he certifies that I was working.
Mr.
70.
So, yeah, I think there are around 2-3 cases filed on that point before this court, earlier to this. Two.
For salary only, my lord.
Salary only.
Yes.
And in no place, in no case I find that that order of transfer 2000 was stayed. So you were not required to join there. Even my Lord Justice, the last order, I think it's my Lord Justice Koteshwar Singh's order.
Yes, my lord.
He has limited it to the period from 26/3/99 to 21/1/2001.
Yes.
In view of this, how can we go beyond this? You have never brought that issue before this
My
court.
lord, then, my lord, I'll have to file a review petition in
You'll
that
have to.
case. My lord,
Otherwise,
for the
the matter is closed.
But, my lord, in this case, my lord, due to filing of the contempt case, I have been terminated by the. my lord,
Rightly terminated. You are not a regular employee. You don't have a regularization order.
No, Lordship, kindly.
You were
see
an
the
ad hoc
term-
sort of a employee.
Lordship, kindly see the termination order, page 61. And they have terminated me, my lord, by order dated 22/6/2023, and with effect from 21/1/2000.
Actually, you're not working from that day. You are a ad hoc sort of a employee. Why should they continue with you? And this court had also said till 2001, you pay your salaries, him his
But my lord,
salaries.
The
After
government,
vacations,
my lord,
after
Lordship,
vacations.
Page 59,
Uh,
the my lord, government says the director to pay the salary. But page 60, director say, my lord, asks the. my lord,
I don't
district
think
authority-
this, anyway, subject to what FIDA, but this 21/6/23 is not a erroneous order. As far as this court is concerned.
My lord.
Try your luck.
At this stage, Lordship, may issue notice.
No notice. List this matter again on 25/4/2024. After Bihus,
My lord. Keep it,
have your eat peacefully, we come back, then we will see.
my lord.
65.
This is the one I forgot. Got confused with the other. Yes, Mr. Mondo.
My lord,
Want a hearing today or after Eid?
let notice be issued, my lord.
No,
Since-
I'll not issue notice.
Since my lord, private party is there.
Forget the private party. You have a writ petition already pending before this court,
Yes,
wherein you have challenged the
Despite-
finding of the
yes,
SEBA.
my lord.
Till that is not decided, what remains?
Now-
You're not
My lord,
not the genuine school
Despite
as
the-
on today.
Despite the interim order passed in the earlier writ petition, my lord.
What is the interim order?
Yes. Fine.
Impugn finding of the so and so shall be subject to the outcome of this writ petition. Let the outcome come, then this will be alive. Till now, you're not a genuine school. They need not even consider your case. SEBA said the other school, Moinul Haq,
Yes.
this is the genuine school.
No, that has been set aside by this honorable court. That finding, yes. Lordship, kindly see.
The council, what is this?
Page,
Come
my
to
lord,
page
163.
220.
Page 163, my lord.
Mr. Council, come to page 220. 221. Two 21. Right? Read
221.
the second paragraph.
Yes. Agreed with the order, so also passed with the responsible sense, headed with the responsible, recognized.
So this is the challenge.
Yes,
This is still there.
yes,
This has not been set aside.
yes.
So if that is there, you're not the genuine school till today. Subject to the decision of this court in this writ petition.
Yes.
So how can you make this claim?
Now,
And you come to your prayer now.
earlier order.
You
Lordship,
come to
kindly
your
see.
prayer. Forget the earlier order, Mr. Mandal. There is a fresh order.
Yes.
You come to your prayer.
Yes.
The
Lord,
second page, page 22. Services of the petitioner, teaching and non-teaching staff of Salakura Jonopriya High School, headed by the petitioner,
Yes.
which has already been held till today, that holds not to be the genuine school. So how can we entertain this petition?
Now,
After Eid,
now,
on 25th,
25th,
24th,
24th.
I'm not passing the order dismissal.
Notice maybe.
No, I'll not issue.
Private party is
No.
involved.
Why trouble? Why trouble?
Now then, my lord, litigation of
When you are before this court in the other writ petition, get that thing cleared. Get the findings of the SEBA set aside. You get revived,
Yes. In
then you come claim.
in that case, let this petition along with the
No,
earlier.
we will not. We will not.
Otherwise,
Because
my lord,
today you don't have a standing.
multiple litigation will be
Let it
continued.
be. We are here. We are here. Multiple litigation, we are here. But first finish up your that litigation.
Yes.
Withdraw. Withdraw today or after?
Let it be remain, my lord. Will,
25th.
yes.
24th we will withdraw it. I'll not hear you. I'll withdraw it. I'll ask it. 24th of February. Yeah, Mata.
Timing motion, item 20 to 23.
Mr. Day, somebody was praying for an adjournment here because you were not here. That's why I did not.
In fact, I was in some other.
There is a communication. Mr. Kaushik wants to file an affidavit here. Let him file. On the prayer of Mr. B. Kaushik, Hartley Land Council for the parties, on the prayer of Mr. B. Kaushik, list this matter again after 3 weeks, enabling the state respondents to bring their stand on record by way of an affidavit. Smita, get it here. Get here. So like mine.
Only thing, can a date be fixed?
This after 3 weeks will be, no? Then I will list on here. Idea. After it, 8-5. 8-5.
Timing 25.
May I please, your lordship? My lord, kindly peruse the order dated 9/2/2024 passed by your lordship, my lord. And whatever the petitioner apprehends, my lord, exactly that has happened, my lord.
Oh, that your period has come to an end.
Yes, my lord. And thereafter, the petitioner apprehends that, my lord.
No, tell me, what exactly is your grievance?
Grievance is that new committee should be formed as per law, my lord.
Are you interested in coming back again?
Yes, my lord.
Then you participate.
My lord, she did not get the opportunity. By this letter, my lord, I have produced before your.
We have now who is holding the post?
The respond number 5, because my
Who
lord.
is respond number 5?
Respond number 5, my lord.
We have asked the direct district elementary education to take over charge.
Yes, my lord. And that letter, my lord.
Okay. This copy, have you given it to the district elementary education officer?
My lord, the district elementary education officer on 9/2/2024 itself issued a letter for holding the meeting, my lord, on 17 or 18. But in the letter, my lord.
Did this order reach the district elementary education officer?
Yes, my lord.
Who gave? Who furnished?
The petitioner, my lord.
You furnished?
Yes, my lord.
Then
But
thereafter what he did?
Before furnishing the order, my lord, on 9/2/2024 itself, the district elementary education officer issued a letter, my lord, that I have produced before your lordship, right? Just now, my lord. So, my lord, by this letter, even if, my lord, the meeting would have held in terms of this letter on 17, my lord, then also it is okay with the petitioner. But overwriting the date, my lord, on 12/2/2024, the meeting has been held, my lord.
Make a challenge to that.
No, my lord, regarding that.
Make a challenge. We are not with you.
My lord, because.
You had a term. You had a term.
Yes, my lord.
Not satisfied. You're a social worker. We need people like you. Why do you stick to one forum? Explore other forums. There are many people you have seen about children. Now look after the geriatrics.
My lord.
Elderly people. Look after them.
My lord.
Why only this LP school presidentship? You have done your work.
No, my lord. That is
Mr. Bora?
Yes, my lord.
You had done the work for a period of 1 year.
Yes.
3 years.
Yes, my lord.
Very good. Successfully.
But
now you are a social worker.
Yes, my lord.
Why don't you look after some other avenue? Why this children? Children have become big now.
My lord, that is not
Forget
the
the
issue,
children.
but-
Go.
But she has
Look
the,
after the elderly people now.
my lord,
for
she
3
has the
years.
right to, right for the, same, my lord, and my
There
lord,
there are people.
but
If you're not there also, there will be people.
there will be people, my lord, there may be some other people
Who
also.
has been appointed now?
Respect number 5. In
She has been
violation of the
appointed.
provisions, my lord, there is no 1 week's notice, my lord. And the letter which have been issued by the DEO, my lord, that has been manipulated.
Okay, what we
By-
do is, we permit you to, we'll close this, we permit you to make a fresh challenge to that.
Yes, my lord.
Because there is no challenge here.
But my lord, by the order dated
This prayer has become infructuous now.
but my lord, by order dated 9/2/2024, your lordship directed the departmental council to obtain the instruction, my lord, regarding holding of the.
You have given me that instruction, that is enough, Mr. Bora. So he has held the meeting in persons to 9/2.
Yes,
Okay,
my lord.
he has
And
selected
that-
somebody.
That date has been overwritten as 12/2, my lord. But because there should be a 1 week's notice, my lord. As per the provisions of the act, my lord. 1 week notice, my lord, has to be given, my lord. The petitioner may not be there, but some other person may be also there, but they have secretly held the meeting, my lord, and respond
So
number
what
5
do you want to do? You want to continue with this proceedings or you want to have a fresh challenge?
My lord, we be proceeding, at least the departmental council, let them produce the instruction, my lord, from the DEO, my lord.
Mr. B.P. Bora, D.P. Bora, Learned Counsel for the petitioner submits that in pursuance to the order dated 9/2/2024, the DEO had directed for convening a meeting on 13/2/2024 and a committee with the respondent number 5 as its president has been constituted. Full stop. Mr. Bora submits that the said constitution of the committee is not in terms with the provisions in place governing the manner in which a school managing committee is to be so constituted. Full stop. On the next date fixed, the Mr. Sharma, who is for elementary, Ms. Sutia, Learned Standing Council Elementary Education, shall receive instructions from the District Elementary Education Officer as to the steps taken in the matter after the passing of the order dated 9/2/2024 by this court. List this matter again on 10/5/2024.
Obliged, my lord.
Time being 4.
Yes, Mr. Swigya.
Only on the point of my lord, the doctrine of proportionality, I'd like to submit on this case.
Hmm?
My lord, the allegation is that on 2 occasions,
Have you got that judgments?
yes. Yes. There's no issue on that, my lord. I'm not, my lord, submitting that these past punishment could not have been taken into consideration. Of course, there is some reservation because 2 of the proceeding which was not even concluded, those 2 were also taken into consideration. But here overall, my lord, totality of the circumstances and the alleged, my lord, act, my lord. My lord, the dismissal from service would be, my lord, highly disproportionate. No doubt, my lord, he is a police personnel, my lord. And from the appellate judgment, your lordship will find they have relied on the my lord, command certificate that has been, my lord, exhibited. In both, my lord, the timing was given at 7:30 and 6:30. Whereas the allegation, my lord, that was given or the charges that was framed, that it is 6 AM.
2 days you did not attend that
Yes, I
command.
did not. I have explained.
And
so
your
much.
case is that the command certificates were being given to you at the morning 6 o'clock, 7 o'clock.
My lord, I did not receive the command certificate, what I said, my lord. I said over telephone, the first incident over telephone, they have informed that phone was picked up by my son.
So there was some delay in communicating. with me.
Responding to that.
And second one, I said, while I was informed, I was at home, so I came by bicycle. So thereby I was little late. That is the only explanation, but this has not been taken into consideration. They have gone to the.
What are the judgments you want to rely upon?
Only one judgment, my lord, that is of Mukul Kumar Chaudhary.
Citation?
Logical. I'll just supply one.
Just say.
Year 2010, Supreme Court 75. I rely on paragraph 26. In the past, punishment also, no doubt, my lord, several punishment were inflicted, but two of the disciplinary proceedings were not concluded. That was also taken into consideration. '26. There, he was absent from duty for 6 months. It will reflect from paragraph 26 itself. And he also explained the reason. Then also, my lord, the extreme punishment was given, my lord. The court, in the meantime, my lord, he having been, my lord, superannuated or retired from service, my lord, the age has been gone, my lord. Only the back wages have to be considered.
Yes, who is appearing for the respondents?
More than 16 years he was in service. His family is there, my lord. Two incidents, my lord, that is, my lord, and
Two command certificates.
in the proceeding also nowhere it is proved that these command certificates were served on me or the
No,
person
you
who has.
admitted that one you got late, one you got. It was delayed communicating to you because your son had received it.
Yes. But not the command certificate. It was
No, it's phone call.
telephonic.
phone call,
Yes,
sorry,
yes.
phone call.
But appellate judgment has relied on the command certificate. If that be relied, my lord,
Command certificate was not served on you either. And the termination order is dated
termination order 29/2/2012. my lord. Page 25.
after 12 years. We are reinstating, if we have to reinstate you. Whether you have that fitness today,
Left to their domain.
whether you have that fitness today. Police employee, not a babu. Police,
But all remains up to 60. All remains up to 60.
but you not have been, after we are in your home, you're not going through the PT and all.
It will
Naturally,
be left to the domain of the my lord, authority if they wishes, my lord,
we'll see.
some
We'll
lineage.
see, we'll see, we'll see. But you're not making any submissions on the determination with regard to the punishments imposed earlier,
Earlier,
subject to that too.
that too, my lord. Those two also were taken into consideration. Those were not concluded at that time. That reflects, my lord, in the termination order itself, my lord.
Yes,
Lordship,
What
just
do you-
received the record, Lordship, kindly. pass the
Record?
order. We received the record, Lordship.
we have heard. The
Next, day.
second time I'm hearing him.
Sorry, Lordship. After vacation, Lordship. And fix the matter. After
2
vacation,
o'clock. You go through the records. 2 o'clock.
Lordship.
Okay.
Time being 5.
At 2 o'clock, I may not be available, my lord. It may be hard, but
Oh, we'll have it after the vacations. Heard Mr. P.J. Soikia, Learned Counsel for the petitioner. The Learned Government and Council appearing for the, you are appearing for all the respondents?
All the
All the respondents submits that the records have been furnished to him today. Records of the proceeding has been furnished to, defunct proceeding has been furnished to him today. List this matter again on 23/4/2024.
Obliged. Obliged.
5.
Yes, Mr.
In terms, at the outset, I should apologize, or I was not available on the first call. In terms of the order.
We know,
31
busy councils, we have to make for, we are not worried. You come, we'll do the matter.
31/7/2019, if your lordship looks into the order, it appears that I have concluded my submission with reserving right to reply. And they were supposed to make their submission. But now, since such a long time has elapsed, I think we should begin afresh. But today may not be the conducive day for my senior friend has
Just give me a hang of it. The file did not come to me yesterday. What is that? Give me a hang of it. What was it?
But what has happened, the prescribed format of the application says participation in an event of a national level athlete. Now, the private respondent, she herself admits in a petition that I was selected for the event. I did not participate because at that time I was not feeling well. My family was conservative and all. So far that allegation goes unrebutted. And on the basis of that certificate, she gets into an institute to get her diploma, and now she gets into a post on the basis of that certificate, which is fraud.
Oh.
I'll not say fraud, but it will be too hard, but it is not correct, because if your lordship looks, that's the basically this issue. But I have to take your lordship through some of the documents before I say, for example, your lordship may look into page certificate. The advertisement at page 18 or 17 of the petition. Your lordship. Now your lordship will find that in the page 17 is the type copy along with 3 years degree in BP or diploma in NIS from a recognized physical training institute. Now that again has been amended in a corrigendum, my lord, that your lordship will find at page 19. Now it says from a recognized university with a bachelor degree or diploma. In physical education from a recognized institute. Then your lordship will see certificate. The certificate is at page 34. This certificate on the basis of which she got an admission and on the basis of that diploma, in this certificate, your lordship will find.
You are trying to hint that this certificate was used to get into that NIS
diploma. And on the basis of that, now she got that post also. Now your lordship
But
see
have you challenged the diploma?
but diploma is not challenged. We have challenged her
No,
appointment.
if
Because-
that diploma is held to be valid till now, all benefits that flow will have to be permitted to
That is
flow.
one way of looking. But if you commit a fraud or if you indulge
No,
in
till that certificate is put to challenge.
no, by your lordship-
Indirectly can be,
Your lordship
indirectly can be
Yes.
say that the certificate is now not.
Yeah. Yes, that is one way of looking.
I think
But
that
if your
now I
lordship
remember.
looks at
I
page,
think we deliberated on this issue a lot
Yes.
on the last occasion.
yes. Now, if your lordship looks at page 34, your lordship will find that she was selected.
But Mr.
I think, my lord, we
Moore,
Ah.
as far as this selection is concerned, whether participation in a national game or not is not an issue here.
no,
It's only that NIS certificate.
yes. And participation, your lordship will see that format. Participation cutting out.
No, it's okay. We got it.
Your lordship will see the format at page 30. Page 30. The bottom, higher personal performance of participation. It's not selection.
There was some affidavit in your favor also. I
Yes,
see.
my lord. Your lordship will find that affidavit by the respondent number 5 also. Your lordship will kindly see.
Where? Page number?
You have not marked it the running page. I'm sorry, my lord,
The respondent
we
number?
have failed to mark the running page by
Respondent
the
number?
respondent number 5. Now, if your lordship looks,
Just a minute.
It was filed
Affidavit in opposition by respondent number 5.
Srimati Manorama Das.
Ah.
And now if your lordship looks at page 4.
Hmm.
Page 4, middle portion, my lord. It is stated that the deponent was those selected to represent the All India Inter-Varsity Athletic Meet each zone on the basis of her performance in Inter-College Athletic Meet in the year 1991. But she could not participate in the same
My God.
Inter-Varsity Meet as the conservative family of the deponent did not allow her to participate in the said athletic meet held at Rashi. The deponent was a victim of the social circumstances for not being able
No, I am
to.
referring to the affidavit of respondent number 2.
Yes. Then
Paragraph 5.
respondent number 3 also, your lordship may.
The respondent number 5 does not have the requisite qualification as per Assam Youth Sports, and that's a wrong
Yes.
statement. What is the qualification she is missing out? As per the qualification is there.
Yes, I'm showing the qualification.
It's here. Tell me. Member of so and so shall be
Page
eligible.
18.
Rule,
Page 18 is the qualification, my lord.
rule.
No, but rule is, my lord, this is Assam Sports and Youth
Ah,
Welfare.
it's here,
Recruitment and
you have
Post.
given me a copy. It's here.
It is annexed along with the writ petition.
Hmm.
Yeah. Your lordship will find that rule also in the affidavit in opposition by the respondent number.
Graduates in arts, science, commerce from a recognized university with a bachelor degree or diploma in physical education from a recognized physical training institute. Now, where is the advertisement?
At page 18.
This National Institute of Sports, was it amended subsequently?
Yes, ma'am.
Yes, Mr. Chaudhary.
Page 23.
My eligibility is there. Because, and regarding certificate what has been submitted by the university, my lord, that certificate, in the certificate itself, it is stated that although I was selected, I was only selected. That
But you
much-
could not participate.
that much in the certificate. And Lordship has rightly pointed out that regarding the certificate, that certificate is still in force. And and apart from this, already during pendency of the writ petition, 12 years have elapsed, and regarding delay also, in filing the petition.
She is still a district sports officer, or now she has become a deputy director?
At present, I have no contact with my client, I have no information.
Mr. Go on.
Yes, ma'am.
We'll have it. We'll hear
Yes.
it.
And
Just
your lordship-
one query.
Yes.
Now that there is that requirement for obtaining that diploma, that you must be you must have participated in a national level competition. Where is that requirement? NIS.
Your lordship will look first into the advertisement.
Hmm. Educational qualification. Right?
Now, if your lordship looks into the advertisement at page 18,
Hmm.
your lordship got it?
Yes.
Here at the bottom, National Institute of Sports.
Hmm.
Now, this has been removed from in the corrigendum at page 20.
Well, that's why it's not there in the main act. And her degree is from NIS.
And your lordship knows, but they are, in a large number of cases, the Honorable Supreme Court has said that there could be large
Yes,
number of
that's what I
candidates.
was asking you. NIS is not a mandatory, is not mandated in the rules. Okay, when?
I'm here from 24.
Mr. Chaudhary, when?
On 25.
25. As consented to by the Learning Council 40 parties, list this matter again on 2024 for further hearing.
Give level.
Just.
Yes, I'll also.
Mr. Chaudhary, that point, just try to address.
Any other 25?
Any date, other, whenever it's convenient. I'm here only very long. Whenever it's top of the list matter, no problem. And you can give me a date.
23rd.
23rd,
Not 23rd, no, 26th one.
26, 26, 26.
Yes, ma'am.
Malak, 26.
Yeah,
Admission item 35.
About,
On the last
Anything?
occasion. On the last occasion, my lord,
That
we.
rules have you got it?
No, my. We went to the government press also.
Forget
My
it.
learned brother went there and they searched the entire 78 and 79 gazette, but
We'll
didn't
follow
find.
the
But on the official website, my lord, still the reference is there in the
Not
health
there.
department.
Okay, what more you have to argue?
My lord, two things which we failed to mention on the last occasion. This birth, as per my birth certificate, was already recorded in the service record since 1993.
I'm asking you, what is that basis for that birth certificate? Other than your oral submission,
My lord,
other than your own affidavit, which is a self-declaration.
my lord, in the absence of 1978 rules, because it is not available right
And
now.
The
My lord,
two things, Mr. Your self-declaration,
My-
which comes in the form of an affidavit,
affidavit.
and the earlier matriculation certificate.
Pardon? My lord,
Matriculation certificate. Which one is this court required to now accept? There are decisions that in the face of the matriculation certificate, no other thing is to be looked into.
that is what I'm trying to highlight, my lord. In the absence of anything, because in my service record, it was the birth certificate on the strength of which the date of birth was recorded way back in 1993. And there was no dispute for last 30 years, my lord. Now, the Supreme Court says that if I am not allowed to approach the court for correction of my birth certificate, my date of birth, my lord, at the end of my career, same analogy also applies to the employer,
Mr. Singh,
my lord.
here it's not a replacement or a change. They have corrected. They have
When?
corrected
When,
whenever the government has the power.
no, my lord, the
Government
Supreme
has the power to rectify its own records. There was no interference from this court. No limitation act applies. Mr. Singh, no limitation act is applying there. But when you come before me, I'll have to follow certain
rules and
norms.
regulations, yes.
But that norms, the government is open. If they have a justified material available, they can always proceed.
My lord, in that.
Show me decisions to that effect otherwise.
The decision of which I am talking about, my lord.
There is one
that is
decision of my
Sankarlal-
Lord Justice,
Sankarlal judgment, my lord.
my Lord Justice Amitabh Roy and my Lord Justice Division Bench, Onima Hajorika, wherein the importance of this matriculation certificate has been very beautifully said. Case pertains to, I think, Tea Garden and Provident Fund Association employees, something like that.
It's DB bench, my lord. I will definitely look into that, but
You
before
can
that, may
ask NC Das sir. I think he appeared in that matter.
Sure, my lord.
I forgot this citation. I think sir appeared in the matter. You can.
Kindly
copy.
have a look at this judgment, my lord, of 2022 6 SCC, page 211, and may I pray your lordship to look at para 29. 29. The very reasoning on which an employee is not permitted to raise age correction plea at the fag end of his service to extend his tenure should also apply to the employer as well. It is the employer here who had proceeded on the basis of the age of the appellant reflected in his service book during the later service tenure. Now, my lord, the entire career was dependent on birth certificate. It was the date of birth
Mr.
reflected in the.
Mr. Singh, show me that when you entered your service, why did you not, because you had the matriculation certificate with you at that
My
point of time?
I submitted the matriculation certificate, but
No.
I did not submit the admit card saying that it was not available at that period of time. Now the employer, my
So
lord,
they took up the date on the basis of the birth certificate.
Birth certificate. But
So
what,
a document which you had, you withheld.
no, my lord. We provided the photocopy. We provided, they asked for the original, my lord. The original was not provided because it was not available with me, but photocopy was always there and it was provided to the authority. Now, the authority said over for long 30 years, my lord, to verify it and to record the date of birth as per the.
It causes no prejudice to you, Mr. Kant. It causes no prejudice.
But the, on the
Because
last occasion, my
that
lord,
is something which is there already on records,
no, it
public
was-
document.
it was recorded, my lord, as per the birth certificate.
Anything more?
Yes, my lord.
Hmm.
So for the birth and death registration, my lord, in the absence of the rules. Now.
We are not
were-
satisfied with your certificate.
No, my lord,
I am
kindly,
exercising
kindly-
my 2 to 6 power.
section 13, kindly look at section 13 of birth and death registration.
Come on, proceed. Tell me. And also base it on the statement which you have made in your paragraph 5 of your writ petition.
Paragraph 5.
Again, that date is a hearsay date. Your brother told you, so that became the date.
My lord, you will have to understand in the year 68, my lord, because my
Unfortunately, this
brother is
court-
elder to me.
This
My
court
brother is
does not
elder to me.
understand something.
My lord,
This court has that problem. It cannot understand some few things.
my lord will have to see that this 69 Act, my lord, 1969, I'm talking about birth and death registration act 1969.
Para 13, section 13, what do you have to say on that?
Kindly see, my lord, section 13, it reads delayed because within 1 month, one has to get registered with birth and death. And section 8 says that it is the parents who are to approach the authority concerned. Now, section 13, because it is in case of delay in informing the birth and death. Any birth, section 13, subsection 1, any birth or death of which information is given to the registrar after the expiry of the period specified, therefore, but within 30 days of its occurrence shall be registered on payment of such late fee as may be prescribed. 2. Any birth or death of which delayed information is given to the registrar after 30 days, but within 1 year of its occurrence shall be registered only with the written permission of the prescribed authority and on payment of the prescribed fee and on and the production of an affidavit made before a notary public or any other office authorized in this behalf by the state government. 3. Any birth or death which has not been registered within 1 year of its occurrence shall be registered only and on order made by a magistrate of the first class or a presidency magistrate after verifying the correctness of the birth and death. Now, in our state, my lord, we verified and your lordship can direct the
No,
health
You
authority.
read that paragraph line once more.
Para 3, my lord.
Ah.
Any birth or death which has not been registered within 1 year of its occurrence shall be registered only on an order made by the magistrate of the first class or a presidency magistrate after verifying the correctness.
Show me
of
that
birth.
order.
Now, my
Show me
lord,
that
that is what I am trying to impress upon my lord. In our state, one has to approve.
Our state, that power is with the deputy commissioner, district magistrate.
No, my lord.
You will find it.
Subsection 3.
Unfortunately, the judgment, that 78 rules, I cannot get it. But you have judgments of
My
this court.
the state authority.
Judgments of this court, if you go and look into the judgments passed by this court in the foreigners matters. Foreigners matters, you will get a judge, you will get judgments wherein this point has been dealt with. And it is the deputy commissioner.
No, my lord, the rule says it's magistrate first class. That is what, my lord, nowhere in the entire act says that this power has been conferred in
Okay.
our state, my lord,
Okay,
to district.
okay, we'll go by the act, strictly in accordance with the act.
Now,
Show
my
me
lord,
the order of the judicial
so now
magistrate.
kindly come. to
Now, don't
section-
take a plea that in our state there is something else.
No, my lord, section 30 says that there is power to frame rules. Now, what has happened?
You forget the rules, we'll stick to 13.
So that is what
Show me
I am
that.
trying to say, my lord, this annexure 3 is an affidavit sworn before the magistrate
It's
first
a
class.
self-declaration before the magistrate. Now show me the magistrate had passed an order under section 13(3),
That is what,
inquiring into these facts.
that is what, my lord, at that period of time, these rules not available with anyone. So what
Are
procedure?
you continuing in your service?
No, my lord, because there is no interim protection, my lord. So if your lordship fix, I will look for that judgment your lordship was talking about by DB bench. Give us an opportunity, my lord.
I have given you, I think, the third opportunity.
No, my lord.
One to
He
Mr.
visited my-
Ganguly.
He went to the government press, and since there was no advocate
That's-
coming for the last so many years, he was.
That is the
welcomed
beauty
like
of Mr. Ganguly. I have seen him. He does good research.
No, he went there.
No, I've
That's
seen him. I've seen him. I've seen him in other matters also.
So
He
they
goes
were
deep
also
into the matter.
helpless, my lord. They looked in the entire gazette of 78 and 79, but they could not find, my lord, of any rules of 78. And the different sites, my lord, of the government say that.
List
on-
this matter again. On the prayer of Mr. Singh, list this matter again on 23/4/2024 for further hearing.
My lord, can it be on 1st of May?
1st of May, is it holiday?
No, my lord.
Full on.
It's
Full on.
open.
1st of May, 1/5
Highly obliged.
for further hearing. But Mr. Singh, no further adjournment.
36.
Yes, any development?
Orders of this honorable court has been complied with, my lord. The appointment orders are out.
Oh,
My lord, I have also information that some order has been passed. The contents we do not know, my lord.
forget it. We are not closing the matter. You get yourself
My-
satisfied.
my-
Get all the instructions now that is to flow, and thereafter we will close.
Item 2 and 55, my lord. this is
54,
not
55 to
relevant
deduction.
with the matter, my lord.
Huh?
This is not exactly relevant because there is your lordship has already heard that I'm entitled from 2011, my lord.
Fine, Mr.
Case
Mr. Barbia, we are not closing. We are only getting a confirmation. At least get in. That part, nobody can take it away from you. Because the orders still stand.
My lord, another thing, my lord, the lordship, subject to lordship's
It
convenience.
will be little bit
The
technical.
moment they pass anything contrary to that judgment, it amounts to another point.
No need. This is done at our instance.
That is true.
Mr. Fukan's instance.
54, 56. There is already order.
Any order passed has to be in your case in compliance with the earlier direction.
That is.
But you're not getting any money.
No, man.
So if you get some money from today,
Yeah.
does it harm you?
No, man.
That's all.
But I need.
That was the only intention of this court.
My lord,
To
they
get
have
you
already filed,
something,
my lord.
something so that the sustenance is there.
My-
Rest part, leave it to us. We are there.
That will do, my lord. My case to be segregated from 36.
My lord,
We are not segregating anything.
one critical aspect, my lord, if my learned friend goes back to the earlier order, Sun Bhaguti and Mridula Samaj order, that government's approval, that would be required, my lord. And here, my lord, without government approval, my lord, as per the amended act of Guwahati University, my lord,
Mr.
we have issued the
Mr.
appointment order as per
Mr.
direction of this honorable court. So if they want to go back to the past, my lord,
7178.
then we are ready.
7178.
Item number
Yours is
36.
contempt case number 163.
163 and 197, 597.
597. Item 54.
Mridula Sharma.
My lord, I did
Only one candidate.
only one candidate.
Mridula Sharma.
My lord.
Okay. And this is 4755 and 4434. What is
Other
this?
cases, my lord.
Other
Already
cases.
judgment has been delivered, my lord.
Oh, then you can keep this. This is not for no use here. Mr. P.J. Fukan, Learned Standing Counsel, Gaudiya University has placed before this court an office order dated 9/4/2024, by which it has been stated that the services of the petitioners appointed initially on compassionate grounds and working on fixed pay basis have been brought over to the regular scale of pay with effect from 1/4/2024. Full stop. It is provided that the petitioners shall now be paid their remuneration, their salaries in the scale of pay as authorized to them. Full stop. List this matter again after 3 weeks, 2 weeks, enabling the learned counsel for the petitioner to make his submissions with regard to the grant of retrospective effect. The requirement to give retrospective effect to the authorization of scale of pay to the petitioner's hearing. Right?
I am permitted to file an additional affidavit on this.
In this connection, the learned counsel for the petitioner is also permitted to file an additional affidavit. Full stop. It is also provided that the order dated 9/4/2024 would not be called upon to be challenged by the petitioners inasmuch as this order has been passed on the persuasion on the persuasion made by this court with the authorities for a regular scale of pay for the petitioners. However, the issue as to whether the said scale of pay should be authorized to them with effect from the date of their initial appointment is kept open to be decided by this court in the present proceedings.
My lord, on the next date, my lord, we'll have the opportunity to, my lord, place before your lordship the res judicata aspect and the approval of the government aspect.
You place, Mr. Everything is open.
Insisting on the retrospective.
You place it.
My lord.
The learned counsel for the respondents are also at liberty to make their respective submissions to contradict the claim of the petitioners. Second one. Contempt case number, item number, Kiman?
Item 54 and 55.
54, 55. It is Mr. P.J. Fukan, learned standing counsel, Gauhati University has placed before this court an order dated 9/4/2024 by which the petitioner herein has been granted the time scale of pay with effect from 1/4/2024. Full stop. On perusal of the Mr. Jai Borvi, learned standing counsel, learned counsel appearing for the petitioner, submits that the order dated 9/4/2024 authorizing the scale of pay to the petitioner with effect from 1/4/2024 is not in connoissance with the directions passed by this court in the thus by this court provide the order violation of which has been alleged in the present petitions. Full stop. This aspect of the matter would be considered on the next date. A copy, Mr. Borvia as well as Mr. Fukan are at liberty to advance their respective arguments in the matter. List this matter again on
After 2 weeks. Okay.
And the date may be fixed, my lord.
2 weeks. 3 weeks को do. Eight, 5/2025. 2024.
Most of it.
No, it will have contempt of electricity.
Item 37.
Some difficulty today, madam, can it be on my second or
Your lordship has earlier heard this matter.
Is having some problem today also again. I also don't
Only
want to
our
trouble them.
difficulty is, my lord, that the fate of 160 students has been involved.
Okay, we'll hear it then at 2 o'clock.
But today some difficulty, madam.
Difficulty.
On my 22nd or 24th, madam.
Convince Mr. Buragan.
But I've already requested, madam.
No, actually, my lord.
The request will
otherwise,
not do, convince him.
No, everything has been happened. PCI has given the NOC. We started the college. Now the university has not given the affiliation. On a executive instruction,
from the department. That you cannot.
That notification, my lord, whereby, my lord, all the pharmacies.
7-Eleven.
To come under the, my lord, Sankaran University.
7-Eleven. But there is still 3 years' time.
Then, my lord, let it be on 24.
There is
or
3 years'
26.
time.
That part is there.
When, Mr. Branagh, when?
Anyway, my lord, if your lordship can give some, that a provisional, affiliation to us,
That's risky. Let us finally give you a thing.
that is correct, my lord. But we are,
The decision in
I-
Toshniwal and all will apply to him. Why this?
but they have inspected the given
Qualification of the
certificate.
government, my lord, that now, my lord, all will have to be, because, my lord, the petitioner is.
I have incorporated that in that order.
Yes, my lord, so some,
Whether the executive decision
my lord.
in such situation under 162 can be taken.
My lord.
Policy
That's where
decision
central-
under 162 in such matters
Lordship.
wherein concurrent list plus
Yes.
the Pharmacy Act can be taken. I framed the issue to that effect.
My lord, that is the only point we can argue, otherwise.
You cannot. You cannot. There are judgments from 1964, full bench, full constitution bench. You cannot. Even it has been said that TMA Pies, TMA Pi, then Inamdar, then there is one more. These names don't stick. It said that it cannot. When it's a mandate that a law has to be prepared, framed, a law has to be framed. A legislature has to frame that law. That 162 route cannot be taken.
And
I have not concluded, I've just framed it as an issue.
22nd or 24th.
We'll see. And Mr. Brahman, why don't you look up for those judgments
Yes, yes, I,
wherein the Supreme Court has said that the policy decision or a 162 thing cannot be done here. There has to be
I will seek that. Another judgment we have already mentioned by the, that is 2021 10 SCC 657.
What is the name of the party?
The party is Pharmacy Council of India, but, versus Dr. S.K.
Toshinwala.
Yes,
Toshinwala.
Toshinwala. Correct. It
Toshinwala.
has clearly said that no other institution has any power above that. My lord, para 10,
24.
20.
24.
24. 24.
List this matter again on, no, 25.
24.
On 25/4/2024. 25 will
Yes,
it be
my
in
lord, it should come in.
that judgment?
My lord.
Can I just have that copy? Toshinwala.
I'll start one copy.
No, I'll just give it back.
Actually, it's already court, honorable court.
Oh, no, not this, not this. No, this is the, no, not this. This is the issue wherein AICT and PCI,
Yes.
which will be the governing one.
Governing.
Then the Supreme Court said it's PCI.
But,
No, that decision is of 2023. Find out. Sorry,
I will make.
it doesn't stick. Citations don't stick.
My lord, that
It's
is enough, my
23.
lord, that you will say 23 or 24. Will
23.
Right.
2023. I'll give it to you. I'll give it. I'll give it. Didi was second. I'll give it to him. You take it from him. I have it written somewhere.
38.
Make please your law.
How about that? Power consolation.
my lord, some instruction was called for, my lord. My lord, in this regard, I have also filed an additional affidavit bringing some, my lord, this appointment of the other teachers, my lord. As lordship want to, my lord, how they were appointed, my lord. Additional affidavit.
Yes. Masutia, what do you have to say?
We have filed affidavit, madam.
Hmm?
We have already filed our affidavit, madam.
Oh, that is a old story.
Yes, my lord.
That is very old. There is orders passed by this court on the last day. That is 1/4,
Lordship may.
requiring you to receive instructions as to why in the event that so-and-so was provincialized in services as a headmaster, another teacher of the said school was not provincialized in terms of so-and-so, so-and-so.
Because madam, in the year 2016 and 17, madam, number of enrollment is 101, madam.
So you provincialized him as headmaster. So if he is provincialized as headmaster, there should be another 3 persons, right?
No, headmaster, I have, my lord, filed additional affidavit, lordship, that, instruction I brought on record, my lord. Lordship may.
Tutor.
Yeah, 2 tutor, my lord, and 1 science. All are tutored. but one-
Then how do you come in?
My lord, as per section 19 and 25, my lord. So,
Because of the large number of students, you want an additional post.
yes, ma'am, additional.
There is no large number of students because my lord, in the year 2016, 17, 101, 17, 18, 101, madam. And 18 and 19 only 154, madam. That is the
So-
recent special.
As per section 25, my lord, after 100, my lord, 1 headmaster, and after, for 35 student, my lord, 1 teacher.
So 100 would be by 35. How much?
1 teacher, ma'am.
1.
Yes, sir. So from that point of view also, my lord.
No. Headmaster, you gone. Headmaster is gone. Don't forget. Headmaster
Yes,
thing is gone.
Yes, sir.
So whether it will be 3 plus 1 now. 3 plus 1 teacher.
Yes, sir.
So 35 into 3 is 90. No, you don't get it. 105.
No, my lord, as per my lord, record, my lord, 155, 2018, my lord.
18 we can't take. We'll have to take 17.
17, 155, my lord.
155.
Yes, my lord. As per our record, my lord. First, may kindly see. Page 26, my lord. So, my lord, 2017, 101. And 2018, 155. 2019, 155. 2020, my lord, 152.
16, 17, 17, 18. How much?
My lord, last you will find in page 27, my lord. 16 is 101, my lord.
17?
17 lordship. This is 17, my lord, 101.
So.
But my lord, as per
Have you filed a reply to the affidavit of the respondent number?
Yes, my lord.
3.
Yes, lord.
What is your reply to para 8?
My lord, I disputed that, my lord.
Tell me how you have disputed it.
Figure, my lord. And lordship was also called for a my lord instruction, and in this regard, they have also submitted, my lord, regarding teachers, student ratio, my lord. That instruction is probably in the record, my lord.
Yes, Ms. Fukan. What to do? Sutia, what to do?
There is no question of my additional teacher, madam, because number of enrollment is 101, madam.
When is the cutoff date? 16, 17, 18, when?
Madam, 2016, 17, 17, 18 also, madam, 101, madam.
Madam, they took 2 years, madam, in their affidavit.
No, I've seen it.
Then also, madam, 101.
They have stated 2017-18 101. But in 18, my lord, 155. In their affidavit, my lord, page 5. So for last 3 years, my lord, the act says, my lord, for last 3 years, my lord. As per section 3:11.
Anything more to add? Yes.
My lord, section 3 of my lord, Roman 11, which speak about, my lord, the enrollment shall be verified with the data as per Dice Code 2009-10 or before as available in the record of the National University of Education Planning. And
So 9-10, how much did you have?
My lord, that record is not available. But my lord, the last line, my lord, there shall be physical verification of student and taking of the record of attendance of student of last 3 years.
You're reading?
My lord, this section 3 of my Assam Education Provincialization of Service of Teachers, my lord, 17 Act.
Provided that for additional post, it shall, this is a ME school?
This is, my lord, our school is, my lord, the upper primary.
Upper primary?
Yes, sir.
Okay. We'll consider. Anything more to add?
No.
Ms. Sudhir, anything more to add? List this matter again on 30/4/2024 for delivery of orders.
All right.
If we find that there is no clarity, we may ask you also to approach the authorities by way of a representation, giving all these details by invoking 311 proviso. Let's see if we can come to a conclusion, fine. If we cannot, then we'll remand back by providing for that.
39.
Yes, Mr. Vishwas.
They're supposed to provide the latest instruction regarding.
Yes.
During the pendency of this matter, my lord, the petitioner has filed an appeal before this office, my lord, and here for the revocation of order of suspension and the payment of his arrear and current salary. So my lord, 2 weeks may be granted so that in the meantime, appeal also will conclude, my lord. This is.
Who is preventing you from considering the appeal, Mr. Sharma? Are we? Huh?
No, my lord, appeal is means consideration, my lord, under consideration here, man.
Where is the order, Mr. Vishwas?
No, that appeal was filed on 12/9/23.
No, everybody is saying suspension order.
Yes.
I want a suspension order.
Well, the other day, they have produced, well, before your lordship.
I think I gave it back. It's not kept back here.
It was not,
You had not received it.
yes, I have not received, my lord.
When was the appeal filed, Mr. Sharma?
Appeal filed was on
13/9/2023.
12/9/23.
And therein you have specifically challenged an order of suspension.
Yes.
Yes.
So
There we have specifically challenged that I was not absent. I went time and again to school. Headmaster is not permitting me to attend.
So why was that suspension order not brought on record of this case?
Well, the last occasion they have submitted before your lordship that they hold an inquiry and they have given a findings regarding inquiry that they want that I should be transferred to other school
Otherwise,
Uh-huh, that
genuine
case, yes,
problem,
yes,
genuine
yes, yes.
problem is there.
Yes, I remember.
Yes,
There were two other teachers also involved.
exactly.
Where is that order? You have that order? What orders were passed after this? Nothing, Mr.
Nothing was, only one is that in view of the Sukurali suspension with effect from 1/12/21, it was passed on 29/8/23. With retrospective effect. Can it be?
Good only for you. Otherwise, that period also would have been unauthorized absence.
Very true.
I remember. Mr. U. Sharma, Learned Council appearing, standing counsel appearing for the Secondary Education Department submits that the appeal as filed by the petitioner in the matter is under active consideration of the respondents. Full stop. Accordingly, list this matter again on 29/4/2024, on which date Mr. Sharma shall place before this court the outcome. The decision has arrived at by the matter by the authorities in respect of the appeal filed by the petitioner with regard to his order of suspension. Full stop. You're getting your subsistence allowance?
Only 4 months I got.
The petitioner shall within the next 15 days be
Clear the all
provided
views,
with his area as well as current subsistence allowance.
Little more time is required, my lord. My lord,
You want more time?
no, on the May month.
May.
First week of May month.
On 6, but within 15 days, release his area as well as current subsistence allowance.
Within 15 days. That must be reflected in the order.
It has already been.
of the-
Item 40.
Lordship, Mr. Ezbora will appear. He is on Lexet Court 1. Matter will be taken after some time.
Okay. What is this? That
Shiksha Mitra's man.
Yeah, we have qualified death, my lord, but age condonation was there was a direction from this honorable court to consider our applications for age relaxation. Thereafter, without considering that, there has been an order rejecting our claim.
this will be, we'll take it after vacations. Let's this matter again after 2 weeks on a date to be fixed by the. Okay, he's coming at 2. We'll take it up at 2.
Much obliged.
41, 42.
Yes, Mr. Das.
Let me start with the 42.
If my lord, this matter may be taken up after vacation, my lord.
Mr. Sharma, as per rule 9, the requirement is that you can appoint a government servant. And government servant term is defined under the provisions of the.
No, I'm not in the second case, Lords.
No, I'm just clarifying. I'll have to answer something on that. Now that issue is before me. 9.4 or 9.5 says that the disciplinary authority can approve any government servant as your defense assistant. And they have to pass an order approving that. Now,
In my case, there is an order.
in your case, you produced a person from the State Bank of India. He does not, in the scheme of the rules, fit into the definition of a government servant. Because government servant therein is somebody who is having a lien or a link with the state of Assam, government of Assam. But they approved that with open arms. Now the issue would be whether they can make a review of that.
Whether that power is there.
Power is there. With regard, now you are on the main issue.
That is for 41, item 41. I will start with the 42.
What do you say? We'll not,
There is
if we
nothing,
go, we'll
Lordship.
go together.
Starting, my lord, the impugn order, rejecting the person which the petitioner has appointed. He has not been part to appoint anyone. my lord.
No, if you
Say
want
that-
to argue, we'll permit Mr. Sharma to start. Otherwise, he'll start.
No, my lord.
After some time, you will start, then I'll be
My lord, let this matter be come up after vacation, my lord, we'll,
convinced, Mr. Sharma. You have a protection now.
Lordship has protected me. That's true, but the only point, Lordship, what I am on, Lordship. Lordship, when you do not get anything, Lordship, I started with something when there is a service method. That let's start with the BK Sharma's judgment or search the name of BK Sharma. And now you have to search the name of UK Naik.
Don't do
We
that.
started yesterday.
What did you get?
And then, Lordship, I get, it is the 2016 CGLR 730.
Pranjal Das,
Direct
SAS
point
officer.
On my case, Lordship, what the Lordship has argued, and the paragraph 17 of that judgment is my case. Simply my case, Lordship. I do not have to argue, I will read the paragraph 17. That is my case. And Lordship, today I know, Lordship, the best person from that man's here, Lordship, he has come for the beautification, and here, Lordship, there is a program at 110. And the compact powder and all that has come.
That is gone. Those days are gone, Mr. Sharma.
Best person.
That will also not
The
stick.
best person of Guwahati from the one beautician has come to the chamber. So, Lordship, I do not want to take the time. But
I
only-
like that phrase, tall, dark, handsome. That is enough for me.
So after reading this paragraph 17, I thought I will read this paragraph 17 and that is my case fully covered. Nothing more.
This is a very good judgment written by Justice.
Lordship. I have read from 1972. It is the special bench.
He has caught the nerve of that.
Yes,
matter.
Lordship.
Yeah.
Lordship, this is the last case I have read, Lordship. I started with 1972. Then when I come to this 2016, I said, all right, 87, 2 GLR and all that is division bench. Then the special bench 1972. It started. Then now, Lordship, after 2006, 60, 330, nothing remains, Lordship, with this of the rule 9.
We'll consider. When?
Immediately after,
Give me a date where there will be no adjournment.
this, any hearing that.
Because if we decide this, that second issue need not be going to. When?
my lord,
Take the convenience of Mr. Sharma also. Mr. Sharma, whenever it's convenient date,
I am always there.
give it to him. We are here.
26 or 30.
We can have it on 23rd,
Yes.
23rd.
It's Tuesday. Right? On the prayer of the Learning Council for the parties, list this matter again on 23.
It is. Lordship, the 24th, Lordship is problem, or the 25th.
25th also no problem.
25th.
25th, 25th, 25th. Does not take much time.
The interim model continue.
The interim order is passed in the, I think it's in the second case.
Yes.
The interim order is passed. Interim order is passed earlier to continue. Silo was in order to put a status quo order, yes. Huh? It was fine.
I'm good.
Yeah, please, Lordship.
Report has come, Mr.
Yes, Lordship, I have predicted that.
May I please, Lordship, before my senior colleague argument, your Lordship, today I got the information that Lordship, I'm no longer holding the position of the president, Lordship, of the SMDC. So this position may be disposed of, Lordship.
Third page is the report, Lordship.
Hmm?
Third page.
Third page.
Is
Yes.
the report by the concerned ADC, Lordship. It is dated 28/12/2018. So Lordship, two lines I have marked, Lordship.
I've seen it.
And Lordship. So they themselves participated in the inquiry
Hmm.
and they were fully aware about the outcome of the inquiry.
Yes.
So Lordship, before he makes a statement that I am no longer the president of the committee, Lordship.
My-
Lordship, this is a fit case where the heavy cost should be imposed
Yes,
against the.
surely.
My lord, during the 2019, we are the president and the vice president of the SMDC, Lordship. During the year 2019, we are the president and the vice president of the school, Lordship. And it is our duty to look after the school authority and for the betterment of the students, Lordship. So based on the news articles and all, Lordship,
Why, when you are in position,
Lordship,
see, I am here holding this, I'm reading this case of
Lordship,
yours. Why
Lordship.
should I rely on a news article or something else? I'll take it out from here only. You are in the helm of the affairs. Why do you have to rely on something else to allege something against somebody else?
Lordship. Lordship, the petitioner number 2 also, Lordship, he expired, Lordship.
Mr. Naik, between page 32 and 33 is this inquiry report. Page 32 of the
That
petition.
is the only copy I have.
No, this inquiry report that is there, it's dated 28/11/2018. And the
12.
and the order by which the lady was kept out was 8/1/18
Lordship,
and
report,
then
report was submitted on 28/12/2018.
11/2018. 28/12/2018. And this, and where can you show that they had participated in this inquiry?
In the report itself, not one blue mark is there. President and second, president and vice president. They are unable to prove the allegations. That line is there.
They had made a, that they participated in the inquiry. Is there any material? Because here it is not very
That I
clear.
have to check, Lordship, but in the report.
Can you just check and tell me? We'll take it up after some time.
Lordship.
Continue. Bro. It will report to term video.
Item 43.
Yes, Mr. Kaushik. Where is Mr. Kaushik?
May please, Your Lordship.
Hmm,
I
Mr.
will
Kaushik.
allow to call me, Your Lordship.
Yes. Have you got the report?
Yes.
Vacancy position.
On a vacancy position, the post which we have filled up earlier, that we have got it, my lord, the present which we contemplated.
The
to fill
fill up earlier, show me. After 2023, 6/2020.
And what we contemplated now, that we have asked from the concerned inspectorate. my lord.
How can you fill up a post of 31/7/22 in terms of that?
Because of this, my lord, before this act came into force, this combined seniority list was prepared by
I got it, but once when you have the act, everything goes.
my lord.
So what should we do? See, 23 vacancy,
Yes, I have seen that.
and these posts are where? In both college as well as inspectorate.
Both
Both.
combined. Now,
Leha. Mr. B. Kaushik, Learned Standing Council, Secondary Education Department has placed on record the breakup of the vacancies as utilized for promotion in terms of the speaking order dated 12/12/2023 and the clarification dated 4/4/2024 issued by the Director of Secondary Education Assam. It is seen that the vacancies issued, with vacancies utilized are had all come into existence after the coming into force of the rules of after coming into force of the Assam Secondary Education bracketed Government Schools bracket over Service Rules 2020. Also, the breakup of vacancies as placed on record by Mr. Kaushik. For the post of senior assistant and head assistant is kept on record. Full stop. List this matter again on 29/4/2024 for passing appropriate orders.
possibly I'll have to take the breakup as to
This
whether,
much is enough.
because this includes both.
This is,
The inspectorate schools, also the government, my lord, which is government school, that is not.
this is enough.
44.
I'll not destroy your behoove by requiring you to prepare an appeal. Prepare the appeal after that.
No, this is the case where the petitioner is seeking pension. My lord. In fact, he has been granted pension with effect from 2003, my lord, by counting his service to 2003. Now, my lord, as per his entitlement, my lord, he is entitled to pension, my lord, from 1991, my lord, because he was a drop teacher, my lord. And his case is covered by my lord, Jivan Teka's case, my lord. That is what I've brought in by affidavit, my lord. Indicating, my lord, that I have been granted pension, my lord, by counting my service from 2003 instead of 1991, my lord.
You're a drop teacher.
Top teacher.
What, how do you factor in Purnima Hore's judgment?
Pardon, my lord?
Purnima Hore's judgment.
My lord.
Judgment of Purnima Hore.
Jivan Teka's judgment covers, my lord.
Huh?
Jivan Teka's judgment covers.
Jivan Deka has been discussed
My
in
lord.
Purnima Hore.
Of course, I have not brought.
Now you have retired on 31/1/2023. That is proximate to that judgment.
1991, this entire school was provincialized.
Now that judgment says it cannot. You cannot,
I have to go through that.
right? When were you regularized?
I was regularized in 2003, my lord.
6th of May 2000.
6th by 2003, my lord.
So you will be entitled to pension.
And this, I'm entitled to pension, but I'm not getting the full pension because my service period is now has been counted, my lord. This doesn't belong.
Yes, Mr.
To that period, 30 years period, my lord.
Mr.
My lord.
Kaushik,
My lord.
what do you say?
One of the last serial 6 of the instruction. Proposal has already been forwarded to the director of pension.
Your pension you have received.
From 2003, that I've received, well, that I'm receiving, well. That's why I brought an affidavit, well. That has been sanctioned.
23/4/2023. 23/4. That's it.
And this pension proposal is from 2003,
2000.
right? Mr. Dury,
Yes.
is this from 2003?
Yes, Lordship, the latest
Qualifying
is the
service?
Earlier proposal was sent back to the concerned head of office on 3/12 for correction of some anomalies, Your Lordship. Now, since the concerned nodal department has sent it, I have to seek the up-to-date instruction. Whether it
So you are receiving pensions?
At the
monthly
moment,
pensions.
yes, yes.
Mr. M. Dr. Learned, counsel appearing for the petitioner submits that the petitioner has now been authorized the pension and pensionary benefits. However, the set calculation of the qualifying period of service has been calculated from 2003, that is 6/5/2003, and not from 1991. Also, the above issue would require a consideration. Accordingly, list this matter again on 8/5/2024.
Well, obliged.
45-46.
Yes. Mr. Bora. Not you. SSA Bora.
SCRT, madam.
SCRT Bora.
There is no further development from that.
We may ask you to take remedial measures.
There is no further development, madam.
Why? You're not interested. You're not taking.
I have to form, madam, take some time, madam. Like, once there is no further development. And the action has been taken by the Director of Education, madam. They need to file an affidavit.
Mr. Nutt, wait for some time. Let's see what they do. If they do it, fine. Otherwise, we will come.
They will do it now or after the judgment is passed.
No, they'll do it now.
No.
I want.
No, Lordship, dispose of this one, and then whatever consequence will follow.
Okay. We are
Just let
closing
them
it.
know.
then. We are closing it.
Yes.
We'll pass orders.
Yes.
They will do nothing for.
Heard the parties at length. List
Yes.
this matter again on 30/4/2024 for delivery of orders.
Obliged, madam.
Can you move DD?
47-48.
As per last order, my lord, they're supposed to respond.
Lordship, in the last occasion, your Lordship sought for the minutes, and instructions have been received, your Lordship. I may be allowed to file my affidavit.
No, no, no. Give me the minutes. This is the promotion to the post of
Lecturer.
technician.
Technical.
I appear to the private respondent.
Yes, what is your stand?
Lordship, today we have filed our affidavit, Lordship, it's proper record.
You are waiting for the case to be listed to file, huh?
Lordship, actually, the department is more important than us, Lordship. I am the beneficiary of this.
Lordship, the
No, I've got it, Mr. Fukan. What is it? Have you got a copy?
not yet.
It is with Mr. Advocate Clerk. It'll come to you. So he does not want anything before Piyush. We'll have it after. You are paying for?
For respondent number 5 in both the cases.
It is stated at the bar that the respondent number 5 has today filed an affidavit in the matter. Full stop. Raised to list this matter again on 10/5/2024, along with the affidavit as filed by the respondent number 4. Full stop. The petitioner is at liberty to file his rejoinder to the accept affidavit, if so advised. Mr. Bora, you are paying for?
40.
Same.
My lord.
Next matter. You are for Mindu Pawan Bodal. Same order. You have filed the affidavit in both the cases or one? Both the cases.
Yes, sir.
Iki order, no?
Lordship, the criteria for consideration is important, so.
We have got it. Mr. Fukan has placed that.
Yeah.
The rules, the criteria before us. Now we
I
have
have
the
annexed
matter.
it also in my,
Huh?
I have annexed it also in my.
A date, my lord.
10th of May.
10/5.
Keep your blessing.
4950.
Item number 49, we have filed our workout number for on behalf of respondent number 6 to 40.
Earlier, my lordship wanted to know only, my lord, that what procedure followed, my lord, which act follows at the time of provincialization of these colleges, my lord. 10 numbers of colleges were provincialized, my lord. In the meantime, my lord, we have filed some RTI application also. We came to know, my lord, that Act 2017, my lord, 2017 has been applied. And in the meantime, my lord, the respondent BTC has filed their affidavit also. And we have filed our reply, my lord, to that. In reply, my lord, we have annexed, my lord, one document which we obtained through RTI, my lord. Page 106, my lord. Secretary, Higher Education, my lord, Government of Assam.
In which case have you filed?
My lord.
Baska or the other one?
Baksa.
Baksa, the affidavit is not on record. The reply is not on record.
Reply, my lord, perhaps, my lord, it is there, my lord, because.
Okay, it has come. It has come. It has come.
106, my lord. Last page. Secretary, my lord, Higher Education issued a letter to the director, to the secretary BTC, that all these 10 colleges do not fulfill the, my lord, condition. In inviting a reference to the subject cited above, I am directed to inform you that 10 numbers of colleges proposed for provincialization do not fulfill the conditions under the Act 2017.
So now who has provincialized? BTC, not the
BTC,
government.
BTC. So all 10 colleges are, my lord, established
Mr. Bora,
much later than me.
as far as BTC is concerned, we have two bodies, DLC and SLC. As far as BTC is concerned, DLC is by BTC. And SLC is always by
State.
state.
Because finance is involved.
So, without the approval of the state, can you provincialize?
No, that cannot.
Then how can you, because the
Now that is.
106,
I'll get the instruction what they have.
if the SLC has not approved, how can you
They
provincialize?
have referred, my lord, minutes of some meeting, my lord, some committee in their affidavit.
No,
Whether,
we are not worried. We are concerned with only the act.
yes,
And if the act you say that no, SLC that is contemplated under the act, as far as BTC is concerned, it will be a different body. We accept. But if it is the same SLC, because I've got other cases also wherein after DLC matter is sent to the director here or the secretary here for placing.
Director will have to take. Finance is involved here.
So if that is the stand of the government, that these colleges, 10 colleges, none of them fulfill, how can you provincialize? Who is paying their salaries now? Yes. Who is paying your salaries? Are you getting salaries?
Till date, we have not received.
Mr. Ramsay, you are getting your salary?
No. Yeah.
Pro bono case.
Well, they referred my notes. Whether my notes override.
No, no, cannot. Show me that minutes.
The India affidavit.
Para.
Running page number 53. 53 and 54. Every district, two colleges are provincial.
Para 10. Page 49.
Annexure 1. And where is that 106? What is the date of this minutes, Mr. Kolita?
14/12/2023, my lord. And that was 30th of June to 2023.
Before that?
Yes.
Mr. Bora, learned standing council, S. Bora, learned standing council, BTC, shall receive instructions as to whether the colleges that have been, Mr. S. Bora, learned standing council, BTC submits that the colleges in the BTC area, provincial colleges in the BTC area were provincialized by following the provisions of the 2017 Act. Also, the petitioners, by way of filing an additional affidavit, has brought on record a communication dated 30/6/2023, wherein the government in the higher education department had intimated the BTC authorities that none of the colleges sought to be now provincialized fulfill the requisite norms under the Act of 2007. Mr. Bora shall place before this court on the next date fixed the minutes or the decision of the state level scrutiny committee pertaining to the colleges in question in terms of the provisions of the Act of 2017. So, in the event the said colleges were so provincialized without placing their cases before the state level scrutiny committee in terms of the Act of 2017, it has to be brought on record by Mr. Bora as to the power so conferred on the BTC authorities to act in deviation from the provisions of the said Act of 2007.
But higher education standing council will have to bring that record.
No, you get it. Why, if you have not sent it to him, where will he find it out? You get it for me. List this matter again on 30/4/2024. If we get a satisfactory thing on that day, we will finish it up.
Yes,
Our name will be recorded for 6 to 14.
Mr. Ardhar,
For 6 to 14, our number 6 to 14.
6 to 14, without salary.
Without salary.
6 to 14, Mr. Ardhar, learned counsel, appearing for the respondents number 6 to 14 is present. Baska college में एक में file pass कर दो and आगे वाला लिख दो list along with this.
Item 58 also my lord, same my lord.
49, you pass this order in 49, 50 को इसके साथ लगा दो.
And 58 my lord.
50? 50 and 58. 50 is tagged, 58 could be tagged. 58. Take it. You go this matter along with item number 49. Take it.
58.
Take this.
Obliged.
Item 51.
Mr. Das, just wait on for something. Some order matters are there. We'll
Fine.
just finish it off
Fine.
and then take up.
Fine, much good.
Orders item 53.
More than 5 years is completed, how the government is sorting the court's order. In terms of the order dated 5/2/2024, newly implemented, we take states upon the newly implemented S1 of 7 and 8. It is as per the order dated.
Seen the office note dated 5/4/2024.
Yes, sir.
Notices upon neither the AD cards nor the answer notices have been received back. Also. From the respondent number 7 and 8. Also. Registry, list this matter again after 2 weeks. Registry to submit an updated status report with regard to the service of notice upon the respondent number 7 and 8. Also. Yes, madam, you are appearing
I
for?
am appearing for respondent number 1 on behalf of SMT 60.
Who is appearing? Nobody nowadays is appearing for respondent number 7, secretary. Okay. Wait for a day. Let's see. If not, next time we will do something.
Specific date is fixed,
2 weeks, we make a mention.
Deeply relaxed.
56.
Notice was served, my lord, and my lord, their appeared name was shown, my lord. And last occasion, they are also directed to submit the instruction as to why the willful and deliberate violation of this order dated, my lord, 17/3/2022, my lord. They did not file any affidavit, my lord. On content number 1.
Mr. P.K. Bora, Lanat, counsel appearing for the respondents. By placing reliance on a communication dated 8/4/2024 issued by the Director Elementary Education, Assam, to the District Elementary Education Officer, Lakhimpur, submits that the process for implementation of the directions passed by this court is under active consideration and authenticated checklist to creation of a supernumerary post with effect from 1/9/2004 in respect of the petitioner herein has been directed to be placed before the Director, Elementary Education, Assam. Accordingly, he prays that the matter be adjourned today for 2 weeks so as to apprise this court with regard to the developments taking place in the matter. So a copy of the communication dated 8/4/2024 as punished by Mr. P.K. Bora, and Standing Council Elementary Education, Learned Council for the respondents is kept on record and marked as X for the sake of it. It's happening, let it happen.
That may be fixed, my lord. Otherwise, my lord.
It'll come, make a mention. Come in the morning sometimes, show your face, it's good, feels nice.
My lord, last of April, my lord, any day.
No problem, Mr. It will come.
57.
Instructions are, we are awaiting the approval of the finance department, but it was endorsed to the finance department.
Connected to the contempt case.
Stipend teacher.
Connected contempt case, your lordship has made an observation not by your lordship.
Oh, Purnima Hore.
Yes.
Yes. List this matter before any other bench without me. I argued that matter.
Yes,
How can I?
59.
Yes.
And have this habit of pointing it out. I forget sometimes.
But here in this matter, my lord, the I was filed for stay of the impion approval order that was passed by the DO Dhubri. Wherein, my lord, the respondent number 9 was shown as the president of the school managing committee, my lord. Whereas, my lord,
Yes, Mr. Fukon.
Lordship, in this matter, we have already written to the directorate. The directorate has written to the DEO Dhubri
for the concerned instructions, Your Lordship. But what has happened, Your Lordship, he's under bereavement, Your Lordship.
Who?
The DEO, his father has expired. Therefore, my lord, the department has sought for another week, Your Lordship. They'll
Mr.
in the meantime get the.
A. Fukan Learned Council, Learned Standing Council, Elementary Education Department submits that the instructions in the matter is to be furnished by the District Elementary Education Officer at Dhubri. However, the incumbent in the said post is in bereavement, and accordingly he submits that the matter be adjourned and fixed after 2 weeks, so as to enable the department to place on record the required instructions. Also, prayer accepted. List this matter again on 34, 29/4. 29/4.
29.
29.
EPF. All right.
Yeah, I am a pass. I had pass very well.
60.
This case also your lordship cannot take up because for the response in the connected case, your lordship appeared before the
What is that?
against the petition number 2. This is with regard to my lord, a review.
Review of an order wherein I appeared.
No, my lord. The petition number 2, he has filed another petition against, in that case, your lordship appeared.
List this matter before any other bench without me. The name somehow rings. I forgot the issue.
61.
Yes, Mr. Bhuyan, why so lazy in coming forward today? Huh?
My lord.
Matter is like that.
No, my lord.
Matter is good.
Good, my lord. Lord, what has happened, my lord? I have been given the academic charts by my lord. Maybe please to find in my eyes at page 19, my lord. But my lord, the drawing and disbursing power has not been given to me.
That is the main thing that has to be given. Academics can wait.
Yes, my lord. And now, my lord, we have found an office memorandum.
Before that, your lordship.
Why have you not given him the financial power?
Before that, your
Academics, you keep it with the inspector.
Your lordship kindly peruse the last order dated 4/3/2020.
I'm not on that. Why have you not given him the financial power?
Your lordship, on that the occasion.
Today we will direct that the financial power will be with him and the academic power will be with your inspector.
His interim peer is rejected, your lordship, on the last occasion.
Oh.
So
where?
INA closed, your lordship.
Where?
On the last order dated 4/3/2024, I would like to place it.
That is on record, my lord. No, my lord, I appeared, my lord. I appeared and it is rejected.
Oh, yeah, that matter. Yes. My lord, this is
Now, my
correct.
lord, we have come up with the IA with an office memorandum. My lord, my lord may kindly turn to page 20, my lord. 10th of April 2000, very long, my lord, old office memorandum.
Mr. Bhuyan, what are the problems that is happening because you are not given the
Problem, my lord, irrespective of my salary, my lord, the other part of the salary and as well as the inspector of school is not stationed, my lord, is required to be roaming around. And she is also in charge holding the post of inspector of school.
We'll ask which is the nearest school near your school, provincial high school, nearest. We'll ask that principal to hold charge of your post.
But my lord, before that, before my charge, my lord, another.
Where have you written that the money is not being disbursed?
In the writ petition, my lord.
No, in the IA.
No,
Writ petition is over. Interim prayer is finished. Now show me in the IA that this is the problem we are facing. That's why I want.
My lord. No, my lord, that statement we have not given, my lord.
Then,
my lord, our basis of the IA is the OM, my lord. Because the OM says that those person, my lord, who has given holding the charge, he should be given, my lord, the drawing and disbursing power also, my lord. This is their law, my lord, operating the field.
this is different. This is different. Now show me the problem. Because I'll have to go across away. I'll have to, the rejection order, I'll have to go except before that, above that, right?
Yes,
So show me that ground.
no. In the rate petition, my lord, we have pleaded, my lord.
No, that is the immediate cost. You're not getting your salaries. Show me where that's.
No, no, sir, that is not there.
Then,
That is not there.
then we are closing this eye.
But my lord, this office memorandum plea I have taken, my lord.
That we will consider in the main writ petition.
In the main rate, it is not been annexed, my lord.
Fine, you bring an additional affidavit, we'll consider
My
that,
lord,
but
may-
not in the
My
I.
lord may keep the IA pending, my lord, along with the IA can be heard after the vacation, my lord. If I
After
can-
Eid. After Eid, okay,
Yeah,
done,
my lord, my lord,
done. List this matter again on 25/4/2024.
my lord.
An endeavor would be made to dispose of the matter
Yes.
on that day. Ms. Das, whatever instruction you get, you get.
Obliged.
And tell me as to why you are putting people as academic in charges, but not with the financial power. And from today onwards, the inspector of schools will hold the academic charge and the teachers will hold the financial power. See how they are suffering. Tell your bosses, seniors of this proposal. Mr. Mojumdar is listening. Mr. Mojumdar, why are you putting these people into trouble? This academic charge, this big things, why are you giving them? You give it to the inspector. He's a B.Ed man. Post requires B.Ed qualification. Give it to him. The financial charge, give it to the teachers. Next date, you tell me. Yes.
When there are
Obliged.
allegations, my lord, of
Next date, we'll finish it up, Mr. Bhuyan.
My lord, my lord.
Time being 40.
Get us. Fourteen. 40.
May I please,
Yes,
my lord?
yes, Mr. Bora.
My lord, here the petitioners, they were engaged as Shiksha Mitras under academic institutes called EGS centers, education guarantees under the education guarantee scheme, your lordship.
I got it. You appeared in this state. You were not brought within that state pool.
Yes.
There was a state
my
pool
lord.
created. You were not recruited.
Only because.
Now, what is your prayer?
My lord, my prayer, this honorable court directed that my prayer for age relaxation be considered, my lord.
Forget it. Age relaxation should be in relation to a recruitment process. There is no point in just relaxing your age. There has to be a recruitment process. My lord, Justice Bujarburu's judgment.
That's annexed, my lord.
Where? Show me.
Page number 47 onwards of the writ petition. And 62 onwards, your lordship, my lord.
No. I want to see that. Wherein he had gone into and examined the. No, not this. Not this. This is of which year?
2019, my lord.
No, there is a judgment thereafter. This is the one, I suppose. AG appeared in this case. The Advocate General had appeared in this case.
Yes, my lord. At that time, he was additional agent.
Additional AG, huh?
Yes, my lord. In this judgment, your lordship, the honorable court has held that there were 3 promises made to us.
But can we stretch that to this extent?
The direction.
Yes, Mr. Bora, what do you say?
Things cannot be, they have missed the bus.
That's it.
That's.
We did not, my lord. Your lordship will consider, they promised us 3 things that until 2014, there would be 3 deaths held.
You
This
have
your
cleared your tape,
Yes.
finished.
I have-
So that promise gone. Next one.
They said that like those who qualify by 2014, the TET exams, they will hold 3 TET exams. If we qualify in those 3 TET exams, they will appoint us as assistant teachers, your lordship. They
Not
have-
assistant teachers. That would be in that state pool, contractual, state pool.
State pool came later, your lordship.
Okay, fine.
Promise was of 2012, your lordship. Minutes are annexed. In that, your lordship, they said that we'll appoint you as assistant teachers by 2014 if you clear the TET exams that we will hold. 3 TET exams were promised to us. One was held. All of those who were promised this become one class, Your Lordship. In 2014, one TET was held, Your Lordship. In 2013, one TET was held, Your Lordship. The other 2 TETs, third one was not held at all. Second TET was held in 2014, October, Your Lordship. October, and thereafter the TET results were not declared. Without any reason, it was declared in 2017, my lord, in the month of September. After 3 years, Your Lordship. And then 3 days after the declaration of the TET results, there was a new advertisement issued, that state pool advertisement, Your Lordship, wherein they said they brought in an age criteria of 43 years, Your Lordship. Then in 2014, Your Lordship, we were all of the appropriate age, below 43 years, Your Lordship. But because of this new advertisement in 2017, Your Lordship, we were ineligible to be appointed. There were 326 of us, Your Lordship. Rest all were appointed. Earlier, by 2014, in the first TET, those who qualified, even those above the age of 43 were recruited, Your Lordship. There was no fault on our part, only because the TET was not declared in time, Your Lordship. And even one TET was not held, but that we have no grievance with respect to that. We qualified the second TET, my lord.
See, that was a policy of the government. State pool was a policy of the government.
Lordship, this on.
Now I cannot go beyond state pool. State pool is there between. You have not challenged that. I don't want a state pool. I want the 2014 promise.
Lordship, that was included in our challenge, Your Lordship. We said that because the state pool.
Come to your prayer.
My lord.
Come to your prayer.
My lord. Herein, I am only challenging the rejection of our prayer. This was after this honorable court's order, my lord. This consideration, Your Lordship.
So vacant post of 353 numbers of posts, that is the state pool.
Yes, Your
But those posts have been abolished.
Lordship, yes. But Your Lordship, thereafter, those persons who were part of this state pool for 11 months, they continue to work, Your Lordship.
No. Only 1,000 something posts were created.
1,100.
353 posts which were not utilized were condoned.
Because
were abolished.
All the posts, 1,400 something posts were within that state pool which existed for 11 months as per the advertisement. But all those rest who were appointed, my lord, were kept, were absorbed, and they continue to work till date, my lord. And these 353 who had crossed the age, my lord, were not
Are you
taken
working
in.
now? No.
No, my lord. And Your Lordship will also consider my prime years, my lord. 30 to 40, I was with the
Can't help
working
it.
at Shakespeare.
Can't help it. File a case for damages, suit for damages.
No, my lord will also consider one aspect. When this honorable court had passed the last judgment, Your Lordship, the abolishment of the state pool was not placed before this honorable
The
court.
state pool was created by way of a policy decision. It was abolished by way of a policy decision. You challenged the policy decision.
No, that advertisement was for 11 months, and that advertisement said that state pool will be for 11 months. We came in time before this honorable court. We said we are not aggrieved by that.
Those state pool people are still continuing.
Yes.
Those within that year they have.
Period was there.
After
And
that,
contractual.
Lordship.
Contractual still did.
If Lordship goes to the page number 90, is the letter he is challenging 1110, that all of other posts are written abolished.
That impugned order.
That letter.
I saw it. Third paragraph.
Well, last paragraph. Draft, now after the honorable high court order. There is no post now.
Anything more, Mr. Day?
My lord, because Your Lordship will consider why this delay happened in consideration, because we were before this honorable.
That this court had already gone into.
No, Your Lordship will consider.
I'll go from there. That stage is over. That earlier judgment this court has already considered.
There, Your Lordship, this honorable court said that these promises were made to us.
Forget
That
the
is why-
promises. The court said that if there is something, condone their ages.
Yes,
Come to the final conclusion.
and this honorable court was.
No, no, come to the
considered
final
that they should have
conclusion.
been in 2014, my lord.
Come to the final conclusion.
70, my lord.
No, no, page 86 onwards, para 69.
Yes, my lord. Before this, may I
But
take
I-
your lordship to 3 paragraphs, your
No,
lord.
no, we'll find, we'll go with the conclusion. We'll go back. You come to the conclusion.
Para 69.
Ah.
Further, as it is the stand of of the government authorities in the education department that the relaxation of age would now be governed by the provisions of the notification dated 3/5/1951 and the notification dated 3/5/91 being equally applicable for all classes of recruitments, the petitioners can still avail the benefits of such relaxation provided in the said notification. And for the purpose, they do not need any resolution through the minutes of the meeting dated 26/2012. In the resultant circumstances, although we are not inclined to accept the claim of any legal rights of the petitioners for a relaxation of the upper age limit as per the resolutions taken in the minutes of the meeting dated 26/2012, but still, as the notification dated 3/5/1951 is equally applicable to all, the petitioners may submit their respective applications for a consideration of their claim for relaxation of the upper age limit in terms of the said notification. In doing so, the petitioners would also have to satisfy that such relaxation of the upper age limit is necessary in the interest of fair dealing or in the public interest.
Now read the next paragraph.
Yes, my lord. The requirement of satisfying the necessity in the interest of fair dealing would be that because of the conduct of the respondent authorities, the petitioners had lost certain entitlements which otherwise they would have had the benefit of had the conduct of the authorities not been adverse to them, your lordship. This paragraph, your lordship,
Read further.
a consideration of the aspect of being necessary in the interest of fair dealing would definitely not include the personal hardship that a prospective candidate may suffer because of being overage, as there would be many in the open market who would also like to have a government employment, but for being overage and as because the government employment was not available, they are facing a personal hardship. In consideration of the necessity in the interest of fair dealing based upon a personal hardship or desire of a candidate, in our view, would be a violation of Article 14 as it would be discriminatory against any such other prospective candidates who also seek a government employment, but unable to get it for being overage in the meantime.
So this court had not issued any mandamus. It had left to them. And this court had also not directed that once your age is condoned, you must be provided with an employment. Although that might have been your prayer, that was not considered by this court.
No, your lordship will kindly. look
And
at
when
one
they
tab.
come up and say that the posts that were there were already abolished, I'll have to first bring back the post.
No, your lordship, honorable court had also taken.
It
into
is a case
consideration-
where the person had a heart attack and a pacemaker or something is to be fit, but in the meantime, he died. So the doctor will have to bring back his atma, put it inside, then do the operation. That is your case.
No, in this case, my lord, this honorable court had taken into consideration that what would have
We
happened
are only considered,
in 2014.
no, Mr. Dev, we are only looking to the final conclusion.
No, my lord, the honorable court had taken into consideration what is the notification applicable in 2014.
I'll be only concerned with the directions. Right? And see whether that directions have been implemented. They say, now we don't have a recruitment process. So how can we bring it? Satisfy me on that.
My lord, that is why I'm saying that if the honorable court said that there was any hardship caused to us by any act on their part. And
That
if
is an observation.
in paras, last para it is there, my lord.
That's an observation, but that is again qualified with a observation with regard to Article 14.
Yes, my lord, but that would not, that Article 14 would not apply to us.
It will apply to you.
But in our case, my
Now
lord,
show me your representation.
representation, my lord, is a little not well written, my
Page
lord.
88.
Yes, my lord.
So where is that public interest that is to be advanced, which is there? In doing so, the would also have to satisfy that such relaxation is necessary in the interest of fair dealing or in the public interest. Now show me that fair dealing and public interest. Now fair dealing is there.
May I read, my lord? You've said, my lord, that all the others have been absorbed.
That is not a fair dealing. That was there before this court also. At that point of time. And the court did not say that the others have been appointed, maintain parity, give it to you also.
No, lordship.
Anything more?
Lordship, will you kindly consider this? At that time, your lordship, I dedicated my entire prime years to their service, your lordship. They
There are
promised
many.
3 heads.
There are many, Mr. De.
No, my
There
lord.
are many.
But-
You got, how did you get your first appointment as Shiksha Mitra?
Lordship, at that time, I have not annexed those, but
How did you get that appointment?
that was, if you were class 12 passed, your
So,
lordship, then you can.
Not only you, there were others in the field, in the state who were class 12 passed.
Lordship.
So they were deprived. So we'll have to also think for them.
No, lordship, we served your lordship for a decade.
You search the SSC online, Shiksha Mitra, go and search from the other high courts also. You will find that the high courts had enough. Everybody had enough. This court, I'm sorry, I could not go through that judgment. We'll go through anything more.
No, your lordship will consider in our
I'll
state,
consider, give my reasons. Don't worry.
your lordship, then I have 3 judgments, your lordship.
Please prove it. And last time, when did you appear before this court?
Uh,
17.
lordship. This, your lordship, factually, these cases are different, your lordship, but certain principles are, I wanted to bring to the notice of the
Kindly give me the paragraphs.
para 31 in the case of Union Territory of Ladakh and others, your lordship.
31.
Yes, your lordship.
Anything more? Anything more here, Mr. De?
Your lordship, this is not para 31. I'll just point it out, your lordship. I have written the paragraph wrongly. I'll just point it out. The other is Manoj Kumar, your lordship. Para 20 onwards.
Narendra Singh.
For Narendra Singh, I have furnished 2 copies, I believe, your lordship.
No, 1 copy.
Manoj Kumar, your lordship, is another one. There are 20 onwards, your lordship.
Para?
20 onwards. May I read, my lord? Para 20. In public law proceedings.
1 second. Again, just let me go. 20, para 20 and
Your
20 onwards.
20
Okay, fine.
onwards, your lordship. And Narendra Singh. May I read, my lord, from Manoj Kumar?
Okay. Then Narendra Singh?
Narendra Singh is a case, your lordship, where there was a person was denied appointment because an NOC that was to be given by his employer, that is also a state department, your lordship. That NOC was granted late, your lordship. So the Honorable Supreme Court said that because the delay was not attributable to this candidate, he ought not to be deprived of the appointment, your lordship. And in fact, the candidate who was appointed in his place was also directed not to be removed, your lordship.
Para? I think it's on basically on a factual matrix, the Supreme Court went. Fine, got it. You'll have to read the whole thing.
Your lordship, 11.1 is our case also, your lordship. 11.1,
11.1.
page 290, my lord. 11.1 is our submission. This was the submission in before the Honorable Supreme Court also. And 19, 20, 22 and 23.
Fine. Anything more, Mr. Day?
No, my lord. Here also, your lordship will kindly consider one aspect. We came before this Honorable Court in time, when the state pool was in existence, my lord. But when the
But
final judgment was
unfortunately,
passed-
that order did not contain a direction. You had made a prayer from the readings, from the materials that are there in the order. Your prayer was for appointment against that post 353 post in the state pool. This court did not go into that. We'll examine if there is something.
Yes.
But what I find is this court only said condone. It did not even give a time frame. So the impression that this court draws is that if there is a further recruitment, then this will come into being. Not for something which has already passed away. We'll consider, Mr. Beck. Yes, Mr. Bhatt.
Yes, there is no post as of now. That's been abolished.
353 abolished that impugned order. Anything more?
That sounds good.
Why did you abolish that post?
Because there was a.
Because these people were there. Why did you not consider them?
But there, Dr. Will, last two months of page number 102, there is a notification of the government of Assam.
102.
102 of my affidavit. The emergency, madam, may I read my, because though I have my is very small, my lord. The government in the elementary education department approved the creation of the state pool.
Was this brought to the notice of this court earlier?
But that in the
earlier writ petition?
That I don't have the knowledge, my lord.
It is not there in the.
Heard the parties at length. List this matter again on 2/5/2024 for delivery of orders. Mr. Day, work on it. If you get something more, come back on that day. I'll give you time. Okay.
And your lordship may consider, I have, with my rejoinder affidavit, I have annexed 2 advertisements, your lordship, wherein the state has been making recruitments, your lordship, to the post of assistant teachers.
You are also free. You have a TET. You are also free if you are.
No, my lord, I can't because of the age.
Fine. That 51 will come in. It is at that stage that 51 will come in. 1951 OM will come in. You have not utilized that. The orders of this court would come into operation moment an advertisement was issued. You have not utilized that. That's why he used the word, maybe not possible in legal parlance, miss the bus. Apt. You should have. I've seen those notifications. You have not even applied.
Because we were honestly hopeful that your lordship
No.
will.
No,
because of
after the
promise
orders of
made.
this court, you could not have had that view. That's why I was repeatedly telling you, this court stopped short of directing. Only said condone 51.
But your lordship, at that point, this honorable court was not informed that the state pool does not exist. It was heard, your lordship. The honorable court said that the applications be considered for condonation, relaxation of age. And when we went to them, they said that the posts are not there.
We'll consider. Don't worry. We have not made up our mind.
Lordship.
I'm giving you a further opportunity on that day when I pass order 5 minutes, 10 minutes. If you want, you can address me. No problem.
Lordship. Just these judgments I have placed because
I'll read it.
just for one consideration that when we came before this honorable court on the first.
You are trying to
there was
project
time.
a case that when we came, everything was available. But the delay either in the court or by the respondents should not cause prejudice to you. Underlying factor that is your case. Fine.
Most obliged.
52.
Have you got it?
No, Lordship, so far as this report is concerned, this was received from the office of the Deputy Commissioner. Law.
Will not
I'm
proceed
not-
further.
I'm not sure also that.
No,
this is
they
the-
will not proceed
that-
without that imposing cost may not be proper.
Lordship,
We'll
but
accept
that-
his
that-
prayer.
Accept that line, Lordship. One specific line is there. The President Secretary SMDC Nehru Girls College School themselves were unable to prove this allegation. So that this line indicates their presence.
But here we cannot draw a conclusion that they were there. So we'll not.
Give it to your Lordship.
Yes, sir.
I have already submitted my affidavit.
No, you have joined, you are working as a warden now?
I have submitted the inquiry report. I have submitted the inquiry report itself done by the executive minister. There is that.
No, Mr. Baba, you are working now as the
Warden of.
warden of the girls' hostel?
Yes.
You're working?
Yes, when the review petition, review meeting, manual to the review meeting also I have submitted. There is a clear indication, a suggestion that there is no any fault.
Basically, their allegation was against the principal.
He should be immediately principal engaged. That was the suggestion.
No, if there was some more material, we would have imposed cost on them,
Yeah.
but now maybe not possible. Okay. Mr. Your name?
Baplo Chakma Lordship.
Mr. B. Chakma, learned. Counsel appearing for the petitioner submits on instruction that the petitioners do not desire to press the matter any further. Accordingly, the writ petition stands dismissed for non-prosecution. Mr. P. Naik, learned. Standing Counsel SSA is present along and Mr. Prabha appears for respond number four.
Four Lordship.
Dipti Pathak,
Yes.
4. Mr. P. Nayak, Aru Radha, 4. The respondent number 4 is present. The SSA, respondent number 4 are present. Are present. First. Dispose of it.
Humbly obliged Lordship.
51.
You had a close shave today. Mr. Counsel, you had a close shave. When I came in, I thought of imposing a cost of 1 lakh,
Lordship.
but that material is not there, so can't help it.
Lordship. Obliged.
Oh, it doesn't help. Like I'm putting. Very good. A kagaz diya hai wo. If you open.
Lordship, before my learned friend starts, I have a two preliminary objection in this case. First, the respondent is a welfare society. Sorry, it doesn't claim because they are not state within the meaning of Article 12. Secondly, there is an alternative remedy available to the petitioner in form of appeal to the appellate authority.
You filed an affidavit in the matter?
No, Lordship, you are not allowed. If Lordship allow you.
No need. Yes, Mr.
I am relying on two judgments of the Honorable Court in Prabhunath Pandey and another.
With regard to Sainik School,
Yes, Lord.
it has been held that this is
Yes.
not a state.
Yes, Lord. Lordship,
Yes, Mr.
in 22, this Honorable
Thus.
Court consider this matter and in paragraph, just one line, Lordship. In view of the aforesaid conclusion, Lordship, paragraph 7 and 18, Lordship.
This is Army Public School.
Yes, this is
No?
So,
No.
Which one, Lordship?
I argued one matter, RB public.
This is argued by me
Yes, Lordship. And Prabhunath
that
Army School. Pasit,
uh, Sachidananda Shah's
Yes,
case.
Lordship.
Yes, yes.
That this has got no application here.
Yes, Lordship.
I was assisting.
Lordship Raghunath Pandey, same, he was a, that army school.
Raghunath Pandey was,
They managed from regimental fund, that's
No,
why
Lordship.
some society was there.
show me, this one, Prabhunath Pandey.
Yes, Lordship. And Lordship, please to see paragraph 18 of this Sachidananda case.
My Lord Justice,
Actually,
no,
Earlier
President Chaudhary was a counsel
yes,
there.
he was the counsel in that Prabhunath Pandey. I assisted him in that case. Lordship. And Lordship, in this case, Sachidananda Saha.
Army school.
Yes, Lordship, this is an army school.
This is not an army school, mister.
Lordship, I will prove, Lordship, this is a society registered under the.
Fine, but army school is different.
Lordship, may please to decide this, Lordship, may help.
Who pays the salaries?
Lordship.
Salaries?
Society pays.
Society gets it from where?
Lordship, that question was raised
No, tell me, society gets it from where?
from the army funds, Lordship.
Army funds?
Army welfare fund. That's why, Lordship, and Lordship, in this Sachidananda case, in view of the aforesaid conclusion, we. do not
Local
Army
Board of
school is
Administration is GOC.
No, Lordship, that.
The Lordship will kindly see the respondents. Milord, why my friend, senior friend is shying away from going to the marriage?
Colonel Y.S. Parmar, SM, principal.
Lordship, we are.
No, as far as I
Secretary,
know, I
Government
think
of
I had
India.
examined this issue at one point of time. And I know that Sainik school, there are matters pending here.
Secretary, Government of India is.
She appeared in those matters.
Milord, division bench also Sainik school filed writ appeal before the division bench.
Division bench.
It matter went from here and went to DB. My senior, Mr. MS, Gayan
Gayan was there.
filed a writ appeal.
I think I was called by the court in that case as an amicus in one of these matters. One of those matters, yes.
No, Lordship, it is Lordship may held that this is a falls under the Article 12. We have no objection, will, and Lordship, I'm not saying on.
You will go on merits.
Milord, writ petition is my Milord. It's my writ petition.
No, he has
Lordship.
taken a preliminary objection.
No, no,
Mr. Das,
fine.
he
Yes.
has the right.
And Lordship, this question was dealt by this honorable court in Pandey's case. Thereafter in Sachidananda, Lordship, please to see paragraph 18
Of which one?
of that Sachidananda Saha. Lordship.
Sachidananda Sai is
No,
totally,
Lordship,
I know that.
paragraph.
I argued that.
Yes, Lordship. Paragraph 18 only. In view of
Gregory.
the.
See, so good my staff is. Once the office thing is over, they have given it to you. Where will you get like this? See?
Actually, just to paragraph 18 Lordship.
Anyway, no problem. You have taken a call. We will have to reply to that also.
Lordship, we want that in view of the aforesaid conclusion, we do not go into the question of maintainability of the writ petition, and question is kept open for any further deliberation.
Mr. Das,
Yes, ma'am.
today make your arguments on merits.
Yes, I'll
but-
deal with it.
But deal with this also.
Yes, yes.
And Lordship, my further prayer, may be allowed to file a short affidavit on this point also. This is my prayer.
Point is taken. Point is taken, law point,
Yes, Lord.
already taken.
No, that is.
And
already-
we will require Mr. Das to make a submission on that.
And Lordship, our pleading are not on the record, although we are.
I want the records.
Yes, record is with us, Lord.
Or are you taking an objection that this, you will have to file a written statement, affidavit in
If you
opposition?
don't say allow, we will file on, within a sort of.
Tomorrow?
Tomorrow it will be difficult.
Because that was the understanding that there will be no affidavit filed, but the records will be proven.
No,
Now that you have taken a plea, you are permitted to file a
Tomorrow
written
it will-
statement, but
Maybe
that written statement should come.
because I have to file written argument in some other cases, so I have to.
Ms. Diane will make it
That's it.
tomorrow. Tomorrow you file it. Let
Fine.
them file it.
Fine.
We'll not keep any technicalities in the view.
No, that's good also, Milord.
And where is my written
It's
statement?
there in the file. Milord. Last occasion I have given Milord.
Yesterday I did not get it.
The two sets of, one is list of date type.
Hey, it was
I'll give Milord, I have
No, no,
got copy.
it
I'll
was a
copy-
digital written argument code, sir. Yeah, that's him to put them. Yeah.
Milord, one is like list of dates type and one.
Ha.
Yes,
It got with the order sheets.
yes, ma'am.
Ase.
And one is with regard to salient points, lordship can refer to the salient points, that will assist your lordships.
No, I read it. That
Yes.
day when you gave it, I read it.
Yes.
Okay. We will hear this matter on 23rd.
Not.
You file your affidavit by 18th.
Exactly.
Otherwise, she will be
But we are heavy under heavy pressure.
outside. She will be saying, "What is he? You not spoiled my everything." Mr. Das,
My lord.
Mr. Das,
Yes, my lord.
if I ask Mrs. Gain to file it tomorrow,
Yes.
from here till her house, she'll be
My lord,
18th, the affidavit would be filed. And when?
lord, can it be
Any date, 22 to 26, any date.
25th,
No problem. 25th.
25th? Lord?
We will finish up the admission matters. And if the orders matters are small, we'll finish it up and then we will jump to this.
Lordship can do one thing, subject to what your lordship says, my lord. If it can be kept as part heard, then my number will come up. Lordship, it's up to
Okay.
your lordship.
Okay,
whether
no,
lordship take
we'll
up-
keep it as
Yes,
because I've heard it at length.
yes.
Heard the parties at some length. Mr. Kerr submits that he be permitted to bring on record the stand of the respondents by way of filing an affidavit. So, prayer accept. The affidavit would be filed invariably by 18/4/2024. The petitioner would be at liberty to file a rejoinder thereto on or before 24/4/2024. List this matter again on 25/4/2024 for further hearing. As a part heard item. A to file Mukti.
Much obliged.
Arwasini,